Slide it.
Good morning. Presentation mode දෙකට දාන්න ඕනේ දැම්මොත් ආයෙ අවුල්යි නේද වගේ. දැම්මොත් ඕන. මේක අහන්න බලන්න අර
දාලා බලන්න. දාන්න සර්.
දාන්න. Well, good morning, ladies and gentlemen. The participants from online, do you see the presentation?
Yes, sir. Good morning.
Good morning. Right. Thank you. And let us start our presentation today. The settlement of industrial dispute. How do we settle industrial dispute? Everything has been stipulated in the Industrial Dispute Act number 43 of 1950. So remember, when we discuss the settlement of industrial dispute, the legal provisions are there in the Industrial Dispute Act number 43 of 1950, right? None other than other legislations. This is the piece of legislation which discuss the provisions in relation to settlement of industrial dispute. There are many methods, right? So therefore, I noticed that the title given to me, no, there are two titles. One is settlement of industrial dispute and worker participation, right? Everywhere workers are participating, right? We don't need to discuss separately worker participation. Every, method, because it's the involvement of employer-employee, right? So therefore, my focus, I'm focusing today exclusively the settlement. How do we settle the industrial dispute, right? Well, let us start. Introduction. The preamble of the Industrial Dispute Act says an act to provide for the prevention, investigation, and settlement of industrial dispute and for matters connected therewith or incidental thereto. එහා අනුසාංගික බැඳුණු. ඒ කියන්නේ prevention, වැළැක්වීම. What? මොනවද වළක්වන්නේ? What are we going to prevent? Industrial dispute. What are we going to settle? Industrial dispute. Right. So an act to provide for the prevention, investigation, and settlement of industrial dispute and for matters connected therewith or industrial dispute. We are going to prevent industrial dispute. We are going to investigate industrial dispute. We are going to settle industrial dispute. There are a number of amendments. The latest amendment to the Act is Act number 22 of 2022. දෙදස් විසි දෙකේ තමයි අලුත්ම නවතම amendment ආවේ. For what? Why did we bring the amendments in 2022? Because if the industrial dispute drags for litigation, the litigation or legal procedure takes longer period of time. Finally, maybe settlement or decision may come after 5 years or 6 years. So then the money that should go to the worker, the value of money will be less. Therefore, whoever the employer, the amendment was brought because, in case the employer goes for higher court, right, against the decision, if the decision given in favor of worker, the employer can go to higher court previously without depositing the money as security. Now the amendment was brought. If the employer goes to higher court, definitely the employer has to deposit the amount determined by the LT or arbitrator, whatever, right? So then it will be deposited in account under the Commissioner General of Labor. Annually, interest rate will be added. So one day when the worker gets the money, he will be having money plus interest rate. So that was the reason the amendment was brought to the Industrial Dispute Act. Okay, well, right, these are the amendments. Remember now, I'm repeating, we are discussing the settlement of industrial dispute. All provisions in relation to settlement of industrial disputes are stipulated in the Industrial Dispute Act. So Industrial Dispute Act, the preamble or the objective act says, or it provides for prevention, වැළැක්වීම, investigation, විමර්ශනය කිරීම, and settlement, සමතකරණය of industrial dispute. So, well, this is the structure of the presentation. Part 1 discuss, about preliminary. Part 2 preliminaries. Part 2 functions of the commissioner and circumstances in which industrial dispute will be referred for settlement by conciliation or by arbitration or by industrial court, section 2.4. And the part 3, collective agreement, section 5 to 10, settlement by conciliation, section 11 to 15, and then settlement by arbitration, section 58 to 21. Part 4, industrial code, section 21 to 31, and labor tribunal, section 31A to 31DD. Forget about this structure, right? What do you know? Want to know is, I'm emphasizing you, try to understand the subject matter. What are the methods that we can use to settle industrial dispute? Right? Settlement of industrial dispute. How do we settle? What would be the procedure? Each one. We discussed collective agreement. How do we settle industrial dispute? Through collective agreement, through conciliation, through arbitration, and through labor tribunal. Labor tribunal. Yeah, I will explain to you. It's nothing, it's also an arbitration, right? But it comes under the compulsory arbitration, right? Where the minister has power, right? If the matter is minor, it will be, referred to an arbitrator. but the dispute is major. Arbitrators are selected, 3 arbitrators from 3 or 2, normally 3 arbitrators from the industrial court. Industrial court also, there's a pool, right? Arbitrators, they are appointed by the president, whereas arbitrators are appointed by the minister.
When it comes to practicality, it will be how do we have the industrial courts?
Yes, it is under the labor department. It's, don't misunderstand. When we say court, it's not like, the magistrate court, LT, no. It's the, the pool of arbitrators. This comes under arbitration, not under LT or not the separate court. We define it as industrial court, right? Because the minor matters will be referred for arbitration, whereas the same arbitration, but the matter will be my major matters will be referred for industrial court. They are also arbitrators, right? Don't misunderstand. Okay, when we say court, something feel like magistrate court. No, this is also an arbitrators. They are arbitrators, but they are appointed for 3 years by the president. Right? If they do not have a case, they have to be there at home, right? Once the case is referred, not for all, but selected couple of the arbitrators selecting from the industrial court, pool of industrial. So the matter will be referred for them. Very rare, major matters will be referred. Less than 10 cases per annum. But normally, arbitration, yes. Well, so Industrial Dispute Act, 88, provides for several mechanisms of dispute resolution. Section 3, where the Commissioner General of Labor is satisfied or apprehends that an industrial dispute exists in any industry, he may. This is the prevention part. Look, Commissioner General of Labor is satisfied or apprehends that an industrial dispute exists in any industry, he may. If there is an agreement between the parties for settlement, refer to that process. Second, endeavor to settle by conciliation. Where is the conciliation takes place? Here, the Labor Department. All labor officers, assistant commissioners, deputies, they are engaged with settlement of industrial dispute through conciliation. Out of total industrial dispute received by the Labor Department, 95%, more than 90% are settled through conciliation. Right? Referring for arbitration, very few. The LT cases also, there is somewhat significant number of LT cases, because they can go directly in case of termination without coming to the going to the Labor Department. They can go to LT directly. So, however, remember, the Labor Department receives significant number of industrial dispute per annum, right? More than 10,000, 8,000 to 10,000, if I'm not mistaken. 90% of those cases are settled through conciliation. Less than 10% will be referred for arbitration or industrial court, right? LT is separate. You have to, because if someone is going to LT, the person is not supposed to come to Labor Department. There are, say for example, termination of a person by an employer where less than 15 workers are being employed. then the worker has to go to LT because the employment is less than 15. Labor department do not accept those cases because the Termination Act, the Labor Department has powers with regard to implement the TEWA, Termination of Employment of Workman Act. If the total number of workers is less than 15, then it does not come under that organization, does not come under the TEWA. So then, if something happened, termination, the person has to go to L, not to the Labor Department. Right? First, you need to understand when we say, someone can say affected party, go to Labor Department. First, we need to understand whether the Labor Department has jurisdiction. With regard to, Termination Act, yes, Labor Department has jurisdiction in order to implement the provisions of the TEWA. But TEWA is not applicable for an employer who is employing less than 15 workers. Okay, so therefore, the Labor Department has no jurisdiction with regard to a termination of a worker where less than 15 workers have been employed.
So you, what, when he has got the thing, and LTA both.
No. The person can, if more than 15 workers, then the person can, the terminated worker can approach either LT or Labor Department. Even the person comes to Labor Department, advise within 6 months, if he wants, he can go to LT.
Not to both.
Not to both. Not to both. We have very classic cases, court cases, Supreme Court case, very recent cases. Even what people does is, people come here and settle the matter through conciliation, and then couple of months later go to LT without making reference to the Labor Department. LT, we have a classic example. LT has proceeded. Then the employer go against the LT decision if the decision is given in favor of worker, and go to Provincial High Court. High Court also has affirmed the decision. I mean, the LT decision, and Supreme Court has very clearly, very recent. LT has no jurisdiction if the worker has already come to an agreement under the 12-1 settlement. Right? 12-1 means, you will learn it later. Don't jump. I will explain one by one. Then you will realize. Right? So those are the subject matter. Forget about the stuff. Well, endure the settlement by conciliation. Refer the dispute to an authorized officer for settlement by conciliation. Never happened. It means that instead of the conciliating the matter here in the Labor Department, Commissioner General can appoint someone who has thorough knowledge about labor law, not only labor law, negotiation skills. Someone can be appointed, but there is no provision for them to pay. There is no provision, budgetary allocation to pay for them. But arbitrators, yes, we do have. But if the matter I wanted to, because our sometimes our labor officers, they are dragging. So I wanted to, forget about, you do other inspections, EPF, ETF, gratuity. When it comes to conciliation, I wanted to establish, I undertook a study with the ILO as well. I wanted to establish a pool of conciliators. Then, when we refer the case, then within 1 month, they will settle the case. And their report will be given very soon. But we failed to get the budget line. So otherwise, people in the private sector, they have very good negotiation skill. What we need is when we go for conciliation, not to sit and hear what you say and what the employer says. No, we need to have convinced both parties. Hey, no, these are the consequences. These are the consequences for you. Why don't you come to a settlement? Some kind of, the negotiation skills, communication skill. Right? Labor officers, 90% of them do not have. So nowadays, now because the problem is once they are recruited, we are teaching level O, level O, level O, level. Sometimes when they become like assistant commissioner, they are managers. Executive, they are the, assistant commissioner is the head of the institution. The district assistant commissioner's office. They don't know AR, they don't know AR, they don't know FR, they don't know any government proceedings, only level. But when you become a chief, not only level, there are technical people. You have to have ability to manage those, get things done from others. Okay, well, and third bullet is not happening, right? And then refer to arbitration by an arbitrator, board of arbitrators, or the LT with the consent of the parties. What do you mean by LT here? Why LT here? I said LT is a legal, it's litigation part. Why LT? Because LT president can also be appointed as an arbitrator if they wish. Labor tribunal එකේ president arbitrator කෙනෙක් හැටියට appoint කරලා award එකක් දෙන්න කියලා arbitrator කෙනෙක් හැටියට appoint කරන්න පුළුවන් if they wish. Right? ගොළු කැමති. But කවදාවත් වෙලා නැහැ වෙන්නේ. Because we have arbitrators. LT president, they have lot of things to do. But LT president also can be appointed as an arbitrator. They don't like, refuse, it's okay, we will refer that matter for another arbitrator. Not to anything. But, right. Well, refer here, very important word is there. With the consent of the party. With the consent of the party. What does it mean? What does it mean? Yes, it is called voluntary arbitration. Right? Commissioner General conciliation failed. Then ask both parties, would you like if I refer this matter for arbitration? They ask both parties, the Labor Department asked. Either party objected, then the commissioner has no power to refer that matter for arbitration. Then we come to a deadlock situation. But still we have another option. What? Without or notwithstanding the objection made by the either worker party or workers or trade union or the employer, the minister can refer that matter for arbitration. That is called compulsory arbitration. That arbitration for an arbitrator or an industrial court. The matter is minor, arbitration. Matter is major, industrial court. It is also arbitration. Don't misunderstand. It's not a separate court. උසාවිය නිස්සබ්දවනු එහෙම ආන්නේ නැහැ එතන. ආබිට්‍රේටර්ස්ලා ඉන්නවා දෙගොල්ලෝ එනවා තුන් දෙනෙක් පත් කරනවා බෝවිත. අර ආබිට්‍රේටර් දානකොට එක්කෙනයි. මැටර් එක මේජර් හින්දා ඒකට අර එහෙම තුන් දෙනෙක් එහෙම දානකොට අපි ඒකට කියන්නේ ඉන්ඩස්ට්‍රියල් කෝඩ්. Right. Okay, well. And minister may refer, Minister of Labor, Section 4, may, where he considers the dispute to be a minor dispute, refer the matter to compulsory arbitration. Minister may refer a dispute to an industrial court if the case is major. Both industrial court and compulsory arbitration, not LT. Workman or trade union may complain to the labor tribunal in case of termination of employment, right?
To be done. Be done.
LT has power to intervene into mainly the number one, termination matter. Apart from that, in case once the employment of a workman is terminated, his gratuity has to be paid. If something has happened, lost to the employer by the worker, loss or damage, the gratuity can be forfeited. The amount equivalent to the damage caused. So if worker feels that forfeited amount is not fair, my gratuity has not been calculated properly, then for such matters also, the worker can go to LT. Not because, if the matter does not fall within the Gratuity Act, right? Within the Gratuity Act, such matter also can be entertained by the LT. For example, gratuity is entitled for a worker where he is working, the workplace where he is working has the total number of employment is more than 15 or more than. Okay, I work for a company, 10 workers are there, I have worked 10 years. Asking gratuity, I can go to LT. Whether I get it or not, something else. But because my entitlement is not covered by the Gratuity Act, so therefore, if I feel, normally won't get, but if I feel, I can go to LT. Such matters also can be entertained by the LT. But I mean,
So let's say lawyer has employed more than 50, but in the gratuity they have calculated it good, and the lawyer suffered as a result. So then also you can do.
no, because you have to come to the labor department because you are covered by the Gratuity Act, right?
So only in case lawyer is less than.
Yes. But remember, your gratuity forfeited, if your gratuity, some amount has been forfeited, right? You feel that amount is unfair.
Yeah, that's right.
That for that matter, you can go to LT. But there is no forfeited thing, but your gratuity has not been calculated properly, then you have to approach the labor department. රඳව ගන්න ප්‍රමාණය වැරදි වගේ නම් එතකොට තමයි LT යන්නේ. Right? But කෙනෙකුගේ අවුරුදු 10ට තියෙනවා හදලා නැහැ 9කට විතරයි හදලා තියෙන්නේ. එතකොට LT යන්නේ නැහැ. මෙහෙට කියලා කියන්න. labor department. Gratuity ඒක but by mistake වෙන්න පුළුවන්. අර forfeit කරොත් අඳව ගත්තොත් ඒ රඳව ගැනීම labor department එකට කොච්චරද කියලා සාධාරණීකරණය කරන්න අමාරුයි. ඒක නිසා තමයි LT එකට ඒ අවස්ථාව දීන්නේ. Is it clear? Right. So workman trade union, employer and workman or a trade union of workmen may enter into a collective agreement. Right? The collective agreement contains how an industrial dispute is settled within the organization. Some provisions are included. Right? Based on the provisions in the collective agreement or any other MOU, so they can discuss internet. This one in European countries, this method is a bipartite discussion. This method is being practiced without going for labor authority, they have, the committees. They try to settle disputes within the organization. That is less costly and no any litigation. But the major cases, yes, they refer for labor, but they have that mechanism, right? Even United States of America, within the workplace, they have grievance handling mechanism. They settle most of the dispute without going for authority. I mean, the labor authority. Okay. So, therefore, the labor authority in United States Labor Department, they have many things to do. Research, whatnot. You go to, if you have chance, go to BLS, Bureau of Labor Statistics, right? How many research they have done. Plethora of, the knowledge. I have gone through now or not, but during my tenure as the Commissioner General of Labor and as the Senior Assistant Secretary for Foreign Relations, these days they are in Geneva, International Labour Conference. I think today they are applying today, maybe. But okay, right. These are the methods.
Point.
Yeah.
The collective.
That is what I said. There may be, MOUs, some other agreement with trade unions, not collective, may not be collective agreement, right? Some kind of agreement with regard to settlement of dispute within the organization. If trade unions are, in existence, the employer can come to an agreement with the trade union. Okay, right? We don't need to go for labor authority. We will try to settle if workers have, some problem. We will try to settle, such dispute. We will come to an MOU, memorandum of understanding. They can sign, employer and the worker. If Commissioner General, right, observes, because whatever the case comes to the labor department, right? Then labor authority looks whether they have any internal arrangement. Then the labor authority advise them, hey, look, you have very good, MOU, mechanism. Why don't you discuss internally with the trade? If they will come to us. So that is what we mean by the agreement. Any other agreement? Because in 1950s, the situation was like that. Labor authority, labor department is small, right? No, measure. I mean, the large number of employees, that labor officers and assistant commissioner. So allow the act itself has allowed the parties to settle their dispute at workplace level, right? If automatically, it does not happen automatically. That is why the act has encouraged the agreement to come to an agreement between the parties, workers and the trade unions and the employer, and have some kind of agreement or MOUs, memorandum of understanding, how to settle grievances, disputes, worker problems, each other. Okay, that's what it means. Okay, is it clear? Those who are participating online, is it clear? If you have any question, please raise. Right. So,
Yes,
dispute
clear.
resolution mechanism in the IDV's Industrial Dispute Act. Commissioner, collective agreement, minister, industrial court. Actually, industrial court should also come under the minister. Labor tribunal. So, next one very clearly, look, this is very clear. This is very clear. Right. Industrial Dispute Act. How many mechanisms? How many? I mean, at what level or which level? Commissioner's level, commissioner level, settlement at commissioner level, minister level, and the L. labor right. So under the commissioner agreement section 3.318 conciliation is the major one, right? 3 point, forget about the clauses. Conciliation and voluntary arbitration. Voluntary arbitration. Okay. So agreements include both MOU and collective agreement. MOU, any other agreement and the collective agreement. Right? So if the matter comes to the labor department, commissioner, it is the duty of the labor authority to look at whether do they have collective agreement. Are there any provisions in the collective agreement? Collective agreement in existence, right? In operation. So whether the collective agreement has certain provisions in relation to settlement of industrial dispute. If yes, it is the duty of the labor authority to ask the party, hey, look, you have provisions in the collective agreement or maybe some other MOU. So why don't you try? Coming here, it's a waste of money, waste of time, mainly for the employer and both. So why don't you discuss, sit down at the table within the organization and try to settle it? If fail, yes, come. Okay. The second, the conciliation majority. Remember that. First, right? I think I don't know, right? Whether the participants. So,
Right.
okay. The participants from online, right? Whether I think. Yes, right. There are two types of disputes. Industrial dispute. Industrial dispute. Right. I'm not using this word, but people are using. Some lecturers are using. Some practitioners are using. Industrial dispute. One is right. Right-based disputes. Right. The other one is interest-based dispute. Right? There are plenty, the different, different method, different elements, right? But mainly disputes. People are, saying there are two types of disputes. One is right-based dispute. The other one is interest-based dispute. Remember, for me, there is no right-based dispute. This is exclusively what? Right-based dispute means violation of the law, right? Right-based dispute is a violation of, clear violation of law. Non-payment of wages, it's a dispute, but not actually industrial dispute. That is not, people say dispute, but it's not a dispute. Non-payment of salary or wages, violation of law. We have very clear provision in the law. If salary, wages, leave, terms of employment, right? Non-payment of gratuity, EPF, ETF, those are violations. We are not supposed to conciliate those matters. If salary has not been paid, send the notice to the employer. No second, third notice. Look, you have violated. So pay it. How long do you need? Maximum 1 month. Okay. Yeah, right. If not, file the case with the magistrate court. So we are not supposed to conciliate the violation because right-based is violation, clear violation of. So dispute arises based on non-payment of bonus. People are demanding bonus. There is no provision in law compelling the employer to pay bonus. No. People are demanding higher position. A person. So that is his intent. Then dispute will arise between employer and the worker. There is no provision in law with regard to the promotion. Salary increment, salary hike. No provision in law compelling the employer to pay annual salary hike. No. But people have interest. Right? Workers have interest. Workers need more facility. Workers they are demanding bonus. They are demanding salary hikes. They are demanding, good environment. They are demanding some other facilities. Those then employer does not, listen. Then dispute arises. They go for strike. They complain to the labor department. Transfer sometimes. Illegal transfer. Dispute. But there is no provision in law to address that matter. It may attributed to constructive termination. But it comes late. So those are interest-based dispute. Dispute means actually not the non-payment of EPF, non-payment of gratuity, non-payment of wages, not granting leave. Those are violation of the statutory clause. So anyone is not supposed to conciliate those matters. Instead, taking legal action against the employer. But there are demands from the worker side where we don't have any legal provisions to address those matters. That is why we try the dispute to conciliate or settle at the industry level through dialogue. Otherwise, by the labor department through conciliation. If failed, still the dispute is in existence, then matter will be referred for arbitration. When it comes to termination also a dispute. Right? Dispute. Within the definition of dispute, termination comes. So if termination takes place, then labor tribunal. This is the very clear mechanism we do have in Sri Lanka in settling industrial dispute with regard to the private sector. Whereas in the government sector, we don't have such mechanism. Yes, we do have public service commission, useless, right? And the ombudsman, public petition commission at the parliament, Mahajana Pessan Karya Sabha, labor tribunal. Not labor, administrative tribunal. But well, right? This is the voluntary arbitration, and the minister has power. Look, now I have put under the minister because industrial code, right? This not code is also arbitration, right? But we name it as industrial code because that particular entity has been established by law in order to intervene into a major matters, industrial dispute, right? one arbitrator cannot do it. So therefore, matter will be referred. More, knowledgeable people are there. They are appointed by the president, maximum 10, right? For 3-year term. So out of this 10, 3 will be selected and matter will be referred for them to make a just and equitable award. Just an equitable award. Right. And then compulsory arbitration and industrial court, and then the top, another one, LP part 4A. Is it clear?
Parties can't think after voluntary arbitration, but they have to first go through conciliation.
Oh, let's see. People or the parties, parties involved in the industrial dispute, those who are involved, they cannot go to arbitration. No, because it is the duty of the Commissioner General, right? No employer, no worker directly can go for arbitration, right? This comes under commission. These are the powers of the commissioner in settling industrial dispute. Okay. First, conciliation. Cannot jump to voluntary arbitration. Conciliation fails. They are not come to an amicable solution. Then another step is commissioner asks employers and trade unions, hey, look, now you're not going to, you're not cooperating, you're not compromising. So the matter cannot be resolved. So is it okay if I refer this matter for arbitration? You are the trade union, the employer. Trade union says, no, we don't like. So then I don't have any power. If both parties, yes, okay, we agree. Then I refer this matter, the Commissioner General refer this matter for an arbitration. To investigate and give just an equitable award. Okay, remember, no one can go directly, employer or worker for voluntary arbitration, no compulsion. No, it is the power of the Commissioner General and the Minister. Okay.
So then, say, example reporter, say, the employer give the consent. Commissioner will have the authority, then what would be the next?
So that is what I said. Look, if he fails, goes to Minister.
So Commissioner is supposed to.
Yes. No other person. There are documents to be prepared. Right? Why conciliation failed? Right? What are the best effort? Right? That they have taken. And then around, the Commissioner General has to sign around 15 pages, whereas the Secretary has to sign, if the matter will be referred for Minister, Secretary has to sign another 20, the papers, right? And the Minister as well. The procedure, no one can, because you need to understand, you can settle your problem, employer and the trade union, at organizational level. Right? Organizational level. If the matter involves in relation to termination, go to it directly. Don't come here. Don't come here. Just go to it. Right? Labor tribunal. Whether 15 or more workers or less than workers, you can go to it. For termination matter. If it is not termination, you strike for 10 days, 15 days, asking salary hikes. The employer said no. The commissioner tried to conciliate both parties. Someone many times. Bargain, explain the situation to the trade union and explain to the employer. try to, bridge this gap. And if they come to a, equilibrium level, I mean, acceptable level, then what do? The commissioner do. Commissioner prepare the 12-1 agreement, settlement of agreement, industrial dispute, settlement of memorandum is an agreement. We call it 12-1. 12-1 is section 12-1 of the Industrial Dispute Act. The parties sign it. Commissioner's power has to understand. The commissioner means Commissioner General has all power, but he has delegated those powers up to labor office. Commissioner General involved if the matter is major. Otherwise, no any cases goes to the Commissioner General. Those are conciliated at the labor officer level. If fails, go to the assistant commissioner level. In that token, or office. Assistant commissioner fails, it goes to deputy commissioner. Deputy commissioner fails, it comes to the head office here, the commissioner IR. Commissioner IR try to settle. If fails, refer the matter for Commissioner General. I remember, when I was I assumed duty in 2017. After 2-3 months, it was my first case. For 2 months later, they were discussing that matter. Even though Range Bandala so the commissioner, Mr. Manoj Priyanth at that time, he tried the level best to settle it. Starting from 10, it went up to 3 o'clock. He called me, I asked him, bring it. Half an hour, settled, sign MOU, 12-1 agreement. Because, in order to settle industrial dispute, you have to have convention. Right? Master, 2 weeks. I asked him to make the salary hike. It was top of the more. One of the you could really do the house that nothing with your party. Your party. Lost a year. Then we go to even a 5 feet of wedding around. Here they are. So, Emma Katazala, the CM do it, eh? It has a thing with her. But you wedding her again. Labuan and see it. I am to see it at. So finally, 40 minutes, once it is signed by the both parties in front of the commissioner, right? Commissioner is labor officer. It becomes a legal document, and the terms of that agreement becomes implied terms and conditions of the contract of employment. No party can violate. Okay, repudiate. Yes, you can repudiate, but the repercussions are there. We will come to that point there. Right? Is it clear now? Industrial dispute arises if the dispute in relation to termination of employment directly go to the labor tribunal. Don't go to labor department. This is my advice. But still, instead of, if the total number of employment is 15 or more, there is a probability of getting settlement, early settlement, if you approach the labor department. LT is something like, because why I'm saying that, the labor department try to conciliate. If you go to LT, it's a legal process. The LT was established not with the intention to create a legal body and at that time, but now it has become a legal body because LT presidents are, they have given title as additional magistrate. So they are, behaving like magistrate now. So that is why LT, cases are dragging now. If you come to the labor department, there is a chance of probability. There is a probability to settle it. Okay, right. Well, this is the procedure. This is the power the commissioner has, the minister's power, and LT is separate. Is it clear? The participant from online, is it clear?
Yes, sir.
Thank you. Right. Move to the next one. Right. Industrial dispute, section 48. Read it. Industrial dispute means any dispute or difference between an employer and a workman. එක හම්පුතෙක් එක සේවකයෙක් අතර. එහෙම නැත්නම් between employers and workmen. සේවා ආයෝජකයෝ ගොඩක් සහ සේවකයෝ ගොඩක් අතර. Like plantation. There are 22 RPCs, employers, and more than one trade union when it comes to collective agreement and negotiation. And between workmen and workmen, how come? Workmen and difference between workmen and workmen. What is that? Workmen and workmen. Sorry? No. Yes, but say for example, in one organization, one workplace, there are two trade unions. There are two trade unions. Trade unions themselves have, their rivalry. Then dispute arises between workmen and one segment of the worker and the other segment, the trade union in relation to, workers in relation to other trade. Workmen and workers. Connected with what? Connected with employment, unemployment, terms of employment, conditions of employment, termination of employment, and reinstatement of employment. So, මොකද්ද එන industry dispute එකක් කියන්නේ? සේවා යෝජකයෙක් හා සේවකයෙක් අතර හෝ සේවා යෝජකයන් හා සේවකයන් අතර හෝ සේවකයන් අතර රැකියාව දීම රැකියාව නොදීම සේවා නියම සේවා කොන්දේසි රැකියාව අහිමි කිරීම රැකියාවේ නැවත පුනපත් කිරීම යන කාරණයක් සම්බන්ධ කොටගෙන සේවකයෙක් හා පුතෙක් ඔය කියන කණ්ඩායම් අතර ඇතිවන යම්කිසි සේවකයෙක් සම්බන්ධයෙන් ඇතිවන නොගැලපීමක් එහෙම නැත්නම් විරසකයක්. Right? The industrial dispute means any dispute or difference between so and so connected with this of any person. And the purpose of this definition, workman, includes the trade union consisting of workmen.
An example of employment condition.
Well. Already, the terms and conditions. Wait a minute. When it comes terms, it is specific, right? Salary, social security contribution, leave entitlement, those are terms. Conditions, some of the benefits, working environment, right? Incentives, those are conditions. Conditions are broader. Terms very specific. For example, they may say that employer say Okay, you are entitled for and say medical insurance. That is condition of employment. You are entitled for transportation. Those are conditions. Terms and conditions of employment. Like that. Very clearly මම ඒක අරන් පෙන්නනවා මොනවද මට ලැප්ටොප් එක ගෙනාවා නම් පෙන්නන්න තිබුණා ගොඩක් ඒවා දාලා but remember terms are legal right terms are legal provisions whereas the conditions those are not legal provisions but you know some facilities right welfare facilities working environment transportation what do you call facilities, insurance facilities, medical facilities, those are conditions. Okay, well, so of any person, and right, this is the definition. යම් සේවකයෙක් සම්බන්ධයෙන් හෝ සේවක කණ්ඩායමක් සම්බන්ධව සිංහලෙන් කිව්වොත් සම්බන්ධයෙන් සේවා යෝජකයෙක් හා සේවකයෙක් අතර සේවා යෝජකයන් සහ සේවකයන් අතර සේවකයන් සහ සේවකයන් අතර රැකියාව දීම රැකියාව නොදීම සේවා නියම සේවා කොන්දේසි රැකියාව අහිමි කිරීම සේවයේ නැවත පුනපත් කිරීම සම්බන්ධයෙන් ඇතිවන විරසකයක්. Well, next. One animation done. Right. Who is the workman? Any dispute between workmen in simple way, workman and employer. Employer ගොඩක් ඉන්නම් පුළුවන්. Dispute, employer and a workman. Right. Who is the workman? Workman means any person. Where do you see this? You know, where is this provision is from the Industrial Dispute Act, Workman Section 48. Section 48 deals with interpretation. Definitions. Definition section එක තමයි පොඩි ගොඩාක් තියෙනවා. So the workman means any person who has entered into work under a contract with an employer in any capacity, whether the contract is expressed or implied, oral or in writing, and whether it is a contract of service or of apprenticeship. Apprenticeship in a good workman, right? A contract personally to execute any work or labor and includes any person ordinarily employed under any such contract, whether such person is or is not in employment at any particular time, and includes any person whose service have been terminated. Why is it? Say for example, your employment is terminated. You are not in employment. Why? Still, because the case will be there at the Labor Department or LP. So still employer-employee relationship is in existence. You are not in employment. Why? Until the decision is given, there is an employer-employee relationship. Right? Well, any question so far? Raise the question. That's how you learn. Right. Well, next. Sorry. Employer. Who is an employer? Read this. The employer means person who employs a workman. So you may, resign and start your own business. The small way, you hire a person, this lady, So you are an employer. Who employs a worker? That is what is. අපි කියන්නේ ඒ තනි පුද්ගල ව්‍යාපාරයක්. එහෙනම් මගේ පුංචි ව්‍යාපාරයක් තියෙනවා. මම ඒකට කවුරුහරි බඳවගන්න. So who is the employer? I am the employer. So that is the first one. Who employs a workman? Oh, second, on whose behalf any other person employs any workman? On whose behalf? What does it mean? In your company, it's a limited liability company. Who is taking decisions to recruit work? Company, management mean. When it comes to limited liability, board of directors, right? Partnership, partner. They are the ones who take this part. It is executed by HR manager or HR executive. So that is for the second one. On whose behalf? Any other person. The Adhyakshaka Mandali venuwen, right? Partners la venuwen, the management like next level like that. So on whose behalf? Right? Any other person employs any work. Right? There are three elements under the employer. One, second, this includes the body of employers, whether such body is a firm, company, corporation, or trade union. The third one, any person on behalf of any other person. So, sorry, made a mistake, right? Yes, all right. Sorry. Any person who, on behalf of any other person, employs any workman, right? Any person. Here, any person who, on behalf of any other person, employs any work. Is this? What is the difference between the second one and the third one?
Second one,
Here something mess up. Something wrong. Right? Listen very carefully. Right? Here. Look at this one. What is this? Any person who, on behalf of any other person, employs any worker.
so half of the young person is like this.
Yes, you know, this should come here. Second one. Right? Some typological error, right? Make it here. This come this one. This includes not only this title, only this bullet should come here, right here, and this should go here. Look, any person, HR manager, on behalf of the management, will recruit for it. So this is some psychological error. Any person, මොකද වෙන්න ඕනේ? මේ ලයින් එක ගන්න මේක බුලට් එකක් හැටියට එන්න ඕන කොට වෙන්නද නැත. වෙන මොකුත් වෙනස් වෙන්නේ නැහැ. Make it arrow. ඊට පස්සේ on whose behalf? On behalf of someone එක on whose behalf කියන දෙකක්. On whose behalf? මේක තමයි third party contract. එහෙම නැත්නම් agent and third party contract. Amount again make a putty by mistake. Let me make it. Let me make it right. Let me make it. So just one second. Just 1 second. One second. I will make it. Wait. Okay. Now it's done. Look, any person who, on behalf of any other person, you are an HR manager, right? You are recruiting the junior executive on behalf of board of directors, right? Person, employees, any workman. This includes a body of an employer, body of employer. The third one, on whose behalf? On behalf of someone, නෙමෙයි. Whose behalf? ඒ කියන්නේ මම recruit කරගන්නවා වෙන කෙනෙකුට ඕන වෙලාවට provide කරන්න බලන්න. Third party contact. Okay. Right. ඒකක් පිළේ මොනේද ගිහිල්ලා යන්න කියනවා ඔයගොල්ලෝ. ඔගේ හදාගන්න මේ විදිහට. Well, go and 10 minutes. Now 10:20, 10:30. ඇති නේද?
Recording in progress.
Participants online, there was some, typological errors in your, this presentation. I corrected it. Any person who on behalf of Kianik, Aurung Hari, when, whose behalf Kianik, representing. Representing means act some representative. Okay, well, now if you look at the section 49 of the Industrial Dispute Act, not applicable to public sector employees. Industrial Dispute Act, the provisions stipulated in the Industrial Dispute Act do not apply to the public sector. Who are the public sector workers? Anybody from semi-government here? No. How do we define the public sector employee, sorry? A person who is getting salary or wages from the general treasury. General අර්ධරාජ්‍ය ආයතනවල SOEs වල අය public sector නෙමෙයි. semi public sector. semi public sector අයට මේක ඇතුළත් අදාළ වෙනවා. Bank employees ලට bank employees, not the private. There are three: NSB, BOC, People's. Rural development කියලා කරේක. Others private sector. So section 49, nothing in this act shall apply to or in relation to the state or the government in its capacity as employer, or to in relation to a workman in the employment of the crown state. මේක එන්නේ අර බ්‍රිතාන්‍ය මේ කියන්නේ ඒ තියෙන නිසා ඒ crown කියන කෑල්ල ගණන් ගන්න state or the government කියන එකයි කියන්නේ. කියන්නේ crown state කියලා තියෙනවනේ දැන්. නිදහසට කලින් එහෙම තිබුණේ crown state. Right. Well, powers of the commissioner of labor in settlement of industrial dispute by conciliation. There are, the four: settlement of the dispute by employer and workman under an agreed agreement. Agreed agreement. Right. It includes collective agreement as well. Collective agreement may be MOU, right? They are, in existence. And such agreement, if such agreement has provisions how to settle industrial dispute at workplace level, then the commissioner may ask both parties, as you have some provisions in your agreement, why didn't you follow that one before come to the labor authority? So commissioner directs them, settle at the workplace, and if fail, come back. The commissioner has power to ask the both parties to settle amicably or as per the provisions stipulated in the collective agreement or any other agreement at workplace. Commissioner has power to ask both parties. Sometimes it's not happening practically. It's not happening practically. But commissioner has power to ask, hey look, you have very clear, don't come here. Go and try to settle it. If fail, come. Okay. The second one, endeavor, section 31B. Endeavor a settlement by CL means Commissioner of Labour and his officers. His or her. When her in herලා කීප දෙනෙක් හිටියා. ඉතිහාසෙට ඉඳලා තියෙන කාන්තාව හොඳයි. හොඳයි. කමිෂනර්ස්ලා 23 ඉඳලා මේ වෙනකන් ඒ කාලේ කමිෂනර්නේ කන්ට්‍රෝලර් තමයි බට් නම වෙනස් වෙනවා පස්සේ ඉඳෙන්න. එහෙම මේ දෙවෙනි තත්ත්වයේ පහ පැත්තට ගියාම වලට පේනවා ඇති. ඔය එක පැත්තට ගිහිල්ලා නිකන් වහලා ඇත්තේ නේද? අරලා තිබිච්ච වෙලාවක බලන්න ඔක්කොගේම ෆොටෝස් තියෙනවා 23 ඉඳලම ඔක්කොගේම ඒව තියෙනවා. මට පස්සේ ඇත්තේ ප්‍රභාත් චන්ද්‍ර කීර්තිගේ. ඊට පස්සේ කවුරුත් නෑ දැන් එක් එක. He worked under me. He's quite okay. තුන්දෙනා ඉඳලා. One was Mrs. Pearl Veerasinghe, 1 year somewhere. Then I was senior secretary here. And then after that, my predecessor, Chandani Amaratunga. Then I, assumed UBS. And then after that, I was removed. Another guy was appointed. He is a cabinet appointed. Minister, has to go to the cabinet, ask to appoint a suitable person, suitable or whatever minister wants. But the person should come from the Sri Lanka Administrative Service Special Grade Officer. Grade 3, Grade 2, Grade 1, and then the Special Grade. The person should be appointed from the Sri Lanka Administrative Service. He or she should be a Special Grade Officer. So otherwise, it's not possible. Those are all scheduled for. Scheduled for Sri Lanka Administrative Service. Secretary is not a scheduled for. President can appoint the appointment. There are appointed layer of authorities, layers. President and Constitutional Council at the Parliament. ව්‍යවස්ථාදායක සභාව ඒකෙන් තමයි විගණකාධිපති පත් කරන්නේ Attorney General and Policepati. President appoints secretary, head of the department, including Commissioner General of Labour, Controller General of Immigration and Immigration, Identity Card Office එකේ ලොක්කා GLA දිසාපතිලා පත් කරන්නේ cabinet එකේ. විධායක නිලධාරීන් සියල්ල පත් කරන්නේ TSK. විධායක. Clerical staff එක. ඒ කියන්නේ management assistant officers ඒගොල්ලෝ පත් කරන්නේ ඒකාබද්ධ සේවා අධ්‍යක්ෂකතුමා. Combined Director General Combined Service. එහෙම තියෙනවා. ඊට පස්සේ PN ලත් එහෙම තමයි. Clerical කියන මේ පල්ලෙහා ආයේ drivers ලබන්න. The minister has power to appoint with the permission of the public administration, drivers and KKS. If someone retire and vacancy arises, කෙනෙක් retire වෙලා ගියාම vacancy එකක් ඇති වෙනවා නම් ඒ vacancy එකට driver කෙනෙක් හරි PN කෙනෙක් හරි පත් කිරීමේ බලය විතරයි මිනිස්ටර් කෙනෙකුට. මිනිස්ටර්ස්ලා ඔක්කොම පත් කරනවා කියලා හිතන් ඉන්නේ. ඔච්චරයි පුළුවන්. ඔය සෞඛ්‍යයේ ඉන්න සුවසේවකයෝ පල්ලෙහායි සුවසේවකයෝ කියලා කියන්නේ නර්සස්ලා මේගොල්ලෝ නෙමෙයි. අර ප්‍රොඩියා දින ඒව කරලා ඒගොල්ලෝ රිටයර් වුණාට පස්සේ වේකන්සි එකක් ඇති. ඒ වේකන්සි රිටයර් වීම නිසා ඇති වෙනවනේ වේකන්සි. ඇති වුණොත් ඒකට අර මෙහෙන් අවසරය අරගෙන රාජපරිපාලනයෙන් පත් කිරීමේ බලය එනවා ඒක පත් කරන්නේ එතකොට මිනිස්ටර් තමයි නොමිනේට් කරන්නේ සෙක්‍රටරි තමයි පත් කරන්නේ අමාත්‍යාංශ ලේකම් right and then third one settlement of dispute by an authorized officer commissioner general can appoint an authorized officer ask the person to settle this and give me your vote and the vote. Right. Now make a කවදාවත් වෙන්නේ නැති. But I like this. I like this. If we can establish a pool of competent people, because here taking time, one day today, say for example, labor officer or someone, the fourth parties today. Second calling day, if there is no settlement, another, the reference of business, many things, right? Next calling date may be after 3 months later. I think that is the problem. So if we have competent pool of, people, a pool, and then commissioner can refer the matter for one person. But unfortunately, we need to have a budget line. When we go for a private sector, like freelancers, something like that, we have to pay them good remuneration in the not salary, case by case. Then arbitrate case එකකට කීයද දන්නවද? යාල් 15,000. මේක 25,000 කරනවා මට මතක නැහැ. 15,000. 15,000ට මොම නම් එක් කරා. මේ ඊඩේකේ sorry. මේකේ ඇවිල්ලා කරන්නේ ආර්ථික බෙනිෆිට් එකකටම නෙමෙයි. ඇවිල්ලා මේ perhaps this but I love to share my knowledge. ඒකින් private sector එකෙන් රුපියල් 5,000 පැයකට 5,000 නඩු යන්නම නැහැ. At least 5,000 per hour. An hour. So we had a workshop, very good workshop, last 20 years. Last month, 20 years. You won't believe 80 plus much. But it was organized by an organization called Brain HR. We were paid daily salary. Daily in the sense as resource persons, it was quite good. මාසෙකට එකක් කරගන්න දීපත් in terms of not that much, but because the resource person is paid around 25 to 30% maximum total turnover maximum given. Okay, well, right, here the settlement by voluntary arbitration by an arbitrator or arbitrators or labor tribunal. Here don't misunderstand. Labor tribunal, we are not referring the matter for labor tribunal, but labor tribunal president can be appointed by the commissioner as an arbitrator. Ask, settle this. Then he is not the labor tribunal, he becomes an arbitrator. But never happened. Never happened, this one, the labor tribunal. No labor tribunal president accepts the case. Because we have full of arbitrators, retired people from the labor department, wealth of knowledge acquired throughout around 30 plus years. So around 30. There are some people. One guy, we have referred long back ago, referred a matter for an arbiter. Unfortunately, once, when we refer for arbitrator, the matter is referred for arbitrator. Then until arbitrator gives his or her award, we can't take it back. We take the about ගන්න බලයක්. එයා දෙනකන් ඉන්නවා. එයා දෙනකම් ඉන්න. අවුල්. අවුරුදු 8ක් ගිහිල්ලා තිබෙයි. මං කමිෂනර් ජෙනරල් වුණාට ජීවිතේට ඒ මනුස්සයට ආයෙ කේස් එකක් දෙන්න. That is what we can do. ආයෙ දෙන්නේ නැහැ. ජීවිතේට දෙන්නේ නැහැ. එහෙම ඉක්මනට දෙන අය ඉන්නවා. So we refer matters for them. Right. Okay. This is the power vested with the Commissioner General of Labour in order to settle industrial dispute. So, settlement by voluntary arbitration. It means, as I told you, the parties, right, parties to the dispute, workers and the employer, they consent, they give their word. Okay, conciliation failed, here failed. Then another option is to refer the matter for arbitration. Commissioner asks both parties, okay, you are not coming to an amicable solution. The matter is still in existence, dispute. So I tried my level best, but you are not coming to, a solution. You are not agreeing to settle this. So then I have another option. I can refer this matter for an arbitration. What do you think? We ask from the trade union or workers. And we ask the employer as well. If both parties agree, then the matter is referred for an arbitrator by the commissioner. That is called voluntary arbitration. Why? You have given, both parties have given the consent to do so. Right? In case the trade union say, no, we don't like it. Employer also say, no, we don't like it. The employers are sometimes trying to drag this. If when it comes to, the strikes, employers are trying to, say, give something for workers and ask them to resign. Do you resign? They may ask. Has happened, right? Because, they are trying to drag, this conciliation matter for a couple of months. The employer would like to drag it. Sometimes trade union as well. The meanwhile, employer try to bargain, again, bargain මොකද කරන්නේ සන්තෝෂ මන්දික මොනවා හරි කියලා පායි. එහෙම නැත්නම් ඔබ මැටර් එකෙන් අයින් යනවා. මොකද වෙනවා? trade union මොකද කරන්නේ? සමහර වෙලාවට what they are trying to do is culprit treaty. They try to drag the matter. Meanwhile, employers sometimes make termination is prohibited, right? When a strike is taken place, but some employers do so. And then the trade union communicate the international community, the INGOs, and ask some money to, go for legal action. That is how some trade union gets, what you call international money. This is happening, right, in practice. But anyway, right, these are the methods that the commissioner can follow in settling industrial disputes. Any questions so far?
Let's say, hearing conciliation dispute is not a termination, but
Right.
the
Relating to other six, right?
Yeah.
Other five.
Yeah. Then during that period, can the employer terminate the employee?
Listen, the question is, It is not a termination, but the dispute is taking place. There is a dispute, but not termination. Dispute means any differences between employer and workman with regard to employment, non-employment, terms of employment, conditions of employment, termination of employment, and reinstatement. So not termination, not reinstatement, but maybe with regard to terms of employment. With regard to non-employment. Non-employment means what? උසස් වීමක් නියම දෙන්නේ නැහැ. Right? Interdict කරලා දිනනවා වැඩ දෙන්නේ නැහැ. Unemployed. Okay, right. So then your question is, then it is, in relation. Please raise your question once again. There is a case, right? Dispute case, not termination.
First to counsel.
Yeah.
Then during that hearing period.
During that hearing period. Okay. Right. Employer, in order to terminate the employment of a workman, there is a due procedure to be followed. Under the Termination Act, Section 2 says, no employer shall terminate a scheduled employment of a workman. No employer shall terminate a scheduled employment of a workman without consent of the worker in writing or approval of the Commissioner General of Labour. That is the only legal way that the employer can terminate a workman. Dispute is taking place. The person also involved a part of the dispute. You are asking such person, can the employer terminate such person? No. The simple answer is no. Yes, in relation to disciplinary matter, even though the dispute, if there is a dispute, the conciliation is taking place at the Labour Department during a workman who is a party to the dispute. If the person has done any misconduct, Visamachara, based on disciplinary action, no disciplinary matter, his employment can be terminated only based on disciplinary matter. Is it clear or?
So then, one of the process that have an inquiry, that has to follow.
Look, right. Summarily termination on disciplinary ground is possible. On the spot, yes, possible. But burden of proof at the court comes on the shoulder of the employer. That is why if an employer terminates a workman, better to follow due procedure, at least preliminary inquiry, preliminary investigation. The employer very recently, Supreme Court judgment is there with regard to termination based on disciplinary ground. It went up to Supreme Court because the lower court, LT, the Provincial High Court, granted or order was given in favor of worker, right? And the company went to Supreme Court. Supreme Court affirmed the decision. Why? The problem was not LT. The person came to the Labour Department, right? Labour Department ordered to reinstate. The employer was asked to reinstate. Then employer went to court of appeal against the commissioner order, not order, award, right? Whatever. And then the court of appeal said, yes, Commissioner General is correct. And the employer has to adhere to the decision of the commission. Then employer went to court of appeal, Supreme Court against the decision of the court of appeal and the commission. Court of appeal, Supreme Court affirmed the decision. Why? If the employer is terminating a workman within 48 hours, within 2 days, the reason has to be informed to the workman. Reason. It was not there. And no any other document. The Supreme Court says, where is the document? No document. No worker has been informed within 2 days. So therefore, commissioner has right. Commissioner has right to act under section 2. Section 2 එක කියන්නේ අවසර අරමුත් නැහැ සේවකයෙක්ගෙන් සේවකයෙක්ගෙන් ලිඛිත අවසරයකුත් නැහැ කමිෂනරෙකුත් නැහැ එහෙනම් කමිෂනර් දීප ඕඩරේ හරි කමිෂනර්ට බලය තියෙනවා ඇයි ඩිසිප්ලින් එකකට අයින් කරනවා නම් remember it has to be documented at least preliminary investigation otherwise the case will be dismissed okay අලුත්ම ඒවා කලින් එහෙම තිබුණ නැහැ පරණ නඩු තීන්දුව තියෙනවා ඒවයි මුල් කාලේ කෝට් ඔෆ් අපීල් වල එහෙම ওই දින දෙකක් දැනුම් දෙන්න ඕනේ එහෙම අවශ්‍යතාවයකුත් නැහැ කියලා කියපු නඩු තීන්දුව. හැබැයි අපි පිළිගන්න ඕන කාගේ නඩු තීන්දුවද කොහෙන් එන එකද සුප්‍රීම කෝට්. not the court of appeal. සුප්‍රීම කෝට් එක ඊට වඩා උඩින් 3 bench එකකින් දුන්නේ. ඒක වෙනස් කරන්න ආය යන්න ඕන කොහෙටද? 5 bench එක. සුප්‍රීම කෝට්. Again, well, if on disciplinary ground, you have to document, right, what the mistake or the misconduct the person engaged. And the person has to be informed, say, today terminate, right? And within 2 days from today onwards, right? The reason for termination has to be informed to the worker. Right? And the document has to be there. Document is say this person has done that one, and get statement, and he is guilty for that one. So therefore terminate. Sorry, I don't know. Access within 2 days. The same question I have.
Sir,
Why? Yes.
hello.
Hello.
Sir,
Hold on.
excuse me.
Oh, කියන්න.
සාමාන්‍යයෙන් මේ VRS එක
Oh.
අපි කම්පැනිට VRS ස්කීම් එකක් ඇප්ලයි කරනකොට එතකොට එතනදී ඒක යන්නේ ටර්මිනේෂන් එකක් විදිහද නැත්නම් VRS normal ස්කීම් එකක් විදිහටද යන්නේ?
ඒක යන්නේ මෙහෙමයි. ඒක යන්නේ termination act එකේ section 2 වල කියනවානේ කිසිම කියන්නේ සේවා ආයෝජකයෙකුට විනය කාරණයකට හැර කිසිම සේවකයෙක් සේවකයාගේ ලිඛිත කැමැත්ත හෝ කම්කරු කොමසාරි ජෙනරාල්ගේ ලිඛිත අවසරය නැතුව සේවකයෙක් අයින් කරන්න බෑ. දැන් VRS එකක් දෙනවා කියන්නේ මොකද්ද? section 2 එකේ සේවකයාගේ කැමැත්ත ගත්තා කියන්නේ.
ඔව්.
section 2. හරිද? ඒකට VRS එකකට කැමැත්ත ප්‍රකාශ කරනවානේ.
ඔව්.
මේ VRS එක ගන්න. එතකොට section 2 එකේ section 2 termination act එකේ කියන්නේ එක්කෝ සේවකයාගෙන් විශ්‍රාම යන්න හරි මේ terminate වෙලා අයින් වෙලා යන්න කැමැත්ත ගන්න ඕනේ. එහෙම නැත්නම් කමත PRS කියන්නම ඒ සේවකයෝ කැමැත්ත දෙනවනේ. එතකොට ආයි ඒක ලීගල්, ඒක නීත්‍යානුකූලයි. හැබැයි
එතකොට
සමහර සේවකයෝ ඉන්න පුළුවන්, සමහර අය ඉන්න පුළුවන් PRS එකට එකඟ වෙන්නේ නැති.
ඔව්
තේරුණාද?
එහෙම ඉන්නවා.
එතකොට අයින් කරන්න බෑ. ඒගොල්ලෝ අයින් කරන්න නම් කම්කරු කොමසාරිස් ජෙනරාල් ළඟට ඇවිල්ලා අවසරයක් ගන්න ඕන කරුණු කියලා ඇයි අස් කරන්නේ මොනවද විශ්වාස නැද්ද එහෙම කියලා. එහෙම නැතුව සේවකයෝ අකාලයක් සමයි කියලා එහෙම අස් කරන්න බෑ. එයා VRS එකක් දීලා යනවා නම් ප්‍රශ්නයක් නැහැ. පුළුවන්. පැහැදිලිද?
එතකොට
තව පැහැදිලි.
එතකොට සර් මේ තේවා ඇක්ට් එක අනුව මේ උපරිම ගාණක් කියලාද මේ දෙන්න ඕන කොහොමද?
මෙහෙමයි. නීත්‍යානුකූලව නම් දෙන්න ඕනේ ටර්මිනේෂන් ඇක්ට් එකේ තියෙනවා ෆෝමියුලා එකක්. ඒ ෆෝමියුලා එකට අනුව හැබැයි ෆෝමියුලා එකට අනුව කීයක් ආවත් උපරිමය ලක්ෂ 25යි. මිලියන 2.5යි. හැබැයි VRS එකකින් යවා ගන්න ඕන නම් ඕකටම විතරක් යන එකක් නෑ. සමහර කම්පැනි බොහෝ ඒවා කරන්නේ තේවායකට වඩා වැඩියෙන් පොඩ්ඩක් දෙනවා. රයිට්. එහෙම නැත්නම් මොනවා හරි වැඩි වරප්‍රසාද දීලා යවනවා.
ඔව් දැන් එතන සර් ප්‍රශ්නයක් ආවා. එම්ප්ලොයි කෙනෙක්ගේ සර්විස් එක අවුරුදු 32යි. එතකොට මේ තේව එකේ ඇක්ට් එක අනුව දැන් එතන මේ එයා වැඩ කරපු මාස ගානට හදන්න ඕනේ. ඒ කියන්නේ මේ sorry මාස ගාන පීරියඩ් එක බලලා එතනට මාස කීයකින්ද ගෙවන්න ඕන කියන එකනේ.
ඔව්. මාස දෙකකට හැදෙන්නේ මෙහෙමයි. ඔක ටර්මිනේෂන් ඇක්ට් එකේ හැදෙන්නේ පළවෙනි අවුරුදු 5ට
ඔව්.
මාස කීයද? දෙකක හඩිය බැගින් පළවෙනි අවුරුදු 5ට අවුරුද්දකට මාස දෙක ගානේ. ඊළඟ අවුරුදු 9ට මාස එක අවුරුද්දක සේවයට මාස එකමාර ගානේ. හරි? එහෙමයි හැදෙන්නේ. ඔව් කියන්නකෝ.
ඔව් එතකොට සර් මේ ඒක දැන් ලක්ෂ 25ට වඩා වැඩි ගාණක් තමයි එන්නේ.
ඔව්.
එතකොට ඒක දැන් එම්ප්ලොයි ආගියු කරනවා එයාට ඒ ගාණ තමයි ඕන කරනවා. මොකද අපි කිව්ව ඒ ගාණ මේ උපරිම ගාණ ලක්ෂ 25යි කියලා.
ඔව්.
ඒක මේ ප්‍රශ්නයක් වෙනවද කොහොමද VRS එකේදී?
එමයි VRS එකකට යන්න කැමති නම් හරිද? දැන් ඔය ලක්ෂ 25යිනේ උපරිම ගෙවන්න ඕනි. ඔය ලක්ෂ 25 අරගෙන යන්න කැමති අය ඉන්නවා නම් කරන්න ඕන දේ තමයි මේවා නිකන් කියන්න බෑ. ඔයාලා ස්ටුඩන්ට්ස්ලා ඉන්න කියන්න මේ ඉස්සෙල්ලා
කන්සල්ටින් ගන්න වෙයි.
ඈ
කන්සල්ටේෂන් එකයි ගන්න අපි.
මේ ඔයාලා කරන්න ඕන දේ තමයි උපරිම දෙන්න ඕනේ එච්චරයි තමයි. හැබැයි ඔය ගානේ ප්‍රයෝගය යන්නේ නැති වුණොත් මොකද වෙන්නේ? VRS එක ෆේල්නේ. හරිද?
ඔව්.
ෆේල්. එහෙනම් ඊළඟ ඔප්ෂන් එක තමයි ඔයාලා කියන්න ඕනේ ඇයි වහන්න වෙන්නේ? ඇයි මේගොල්ලෝ අයින් කරන්න ඕනේ කියලා කම්කරු දෙපාර්තමේන්තුවට කරුණු කියලා කමිෂනර් ජෙනරල්ගෙන් අවසරයක් ගන්න. ඒක අවසරය දෙනකොටත් මාස 6ක් විතර ගියොත් එතකන් අර සේවකයන්ට පඩි ගෙන්නන්න.
ඔව් අනිවාර්යයෙන්.
මේ මේවා ලොකු කන්සල්ටේෂන් හැබැයි ඔයාලට ඉන්න කියන්න. එතකොට කරන්න තියෙන්නේ ඉස්සෙල්ලාම අර 2.5 මිලියන් අරගෙන හෝ තියෙන ඒ ෆෝමියුලා එකට අනුව ගන්න යන්න කැමති අයට නෝටිස් එකක් දාලා යන්න කැමති අයට යන්න කියනවා. එතකොට කීප දෙනෙක් හරි යයි. හරිද? ඊට පස්සේ ඒ ටික යන්න ඇරලා තව නැති කොටසක් බහුතරේ නම් එතකොට කියන්න ඕන දැන් මේගොල්ලෝ යන්නේ නැහැ. හරිද? ඔයා දැනගන්න ඕනේ මැනේජ්මන්ට් එකට කියන්න ඒ කියන්නේ වාරසේ ඒ මැනේජර්ස්ලා හැටියට ගිහිල්ලා ඊළඟ ස්ටෙප් එක අවසර ගන්න ඕන. ඔය අවසරය දෙන්න මාස 6ක් 7ක් විතර යයි. ළමයට අවුරුද්දක් යන්නත් වෙයි. එතකම් බේසික් සැලරි එක ගන්න ඕන පඩි නැතුව. හරිද? ගෙදර තියලා හරි. වැඩ නැත්තම්. හරි? ගන්න ඕනේ. ඒකට කොච්චරක කොස්ට් එකක් යනවද? රයිට්? ඒ නිසා බලන්න ඕන වර්ක් අවුට් කරලා සේවකයට තව කීයක් හරි වැඩියෙන් දීලා ඊළඟ ස්ටෙප් එකේදී මෙච්චරක් අපි තේවායකට වඩා වැඩියෙන් දෙනවායි කියලා එතනින් කොටසක් යවන්න. ඉතින් ඔහොම තමයි කරන්න තියෙන්නේ. ටිකට කමිෂන් ගාවට එනවා.
හරි. thank you sir thank you.
මේ රයිට්. එහෙම කන්සල්ටේෂන් අපි කරනවා. හැබැයි ඒක මෙහෙමයි. දැන් මේක මෙහෙම කිව්වට අපි කරන්නේ negotiate කරනවා. වෙනම සේවකයොත් එක්ක වෙනම කතා කරලා මේවත් එක්ක වෙනම negotiate කරනවා ඉතින්. හරි. ඕකේ. Well, so collective agreement or any other agreement, right? The commissioner has power to ask the both parties if the collective agreement or any other agreement, exists, and such agreement has provisions how to settle industrial dispute internally. Then the commissioner may ask the parties, workers, and the trade union, hey, look, you have provisions, please try to settle it at the workplaces. And if fail, so voluntary negotiation, collective agreement, voluntary negotiation, bargaining between parties without the intervention of the commissioner of labor, especially in relation to wages and terms of employment. Commissioner කියනවා විතරයි. Commissioner intervene වෙන්නේ නැහැ. Right? And organization such as the Employers Federation of Ceylon may act as the negotiator or facilitator. Right? A collective agreement must be registered by the Commissioner of Labor by publication in the Gazette to give legal effect to the terms of such agreement. So, in order to have legal effect, say for example, some organization has collective agreement. It has already collective agreement or any other agreement, right? And it contains provisions in relation to settlement of industrial dispute. If both parties agree, right, they can settle at the workplace, right? No worry about that. But if collective agreement, they have collective agreement. Collective agreement also has some provisions settling industrial dispute, but it has not been gazetted. Then such provisions, I mean that collective agreement does not become a legal, the document. In order to have legal, power, collective agreement must be published in the Gazette by the Commissioner General of Labor. Otherwise, no point of having collective agreement. It has to be gazetted. Okay? Right. So what? The collective agreement, section 5.1. In this act, collective agreement means an agreement which is between any employer or employers and any workman or trade union or trade unions consisting of workmen and which relates to relates to the terms and conditions of employment of any workman or to the privileges, rights or duties of an employer or employers or any workman or any trade union or trade unions consisting of workmen or the manner of settlement of any industrial dispute. Right? Collective agreement එකක් කියන්නේ සේවකයෝ සහ සේවා යෝජකයෝ එක්කෙනෙක් හරි ගොඩක් හරි අතර ඇති වෙච්ච එකගතාවයක් ඒක ගැසට් කරාම ඒකට නීතිමය බලයක් එනවා. ඒකේ තියෙනවා මොනවද? settlement of industrial dispute. ඒකට ඒකත් legal provision එකක් හැටියට සැලකනවා. Because once collective agreement gazetted, all terms and conditions, the method, everything becomes legal. Okay? Right. Section 5.2. Reference shall be made in the collective agreement to the parties and trade unions to which and employers and workmen to whom the agreement relates. Again, make collective agreement have a party. Well, the effect of collective agreement. Section 10b. Every employer who is bound by a collective agreement shall keep exhibited, right, conspicuously in the place where the industry that agreement relates is carried on a notice setting out the provisions of that agreement in Sinhala, Tamil and English languages. Again, exhibit කරන්න ඕන. ප්‍රදර්ශනය වෙන්න ඕන. මොනවාද? collective agreement එකේ තියෙන terms and conditions. violating the provisions of the collective agreement is an offence. අවුරු හරි repudiate කරන්න පුළුවන්. හැබැයි labor department එකට බලයක් තියෙනවා. magistrate court එකට ගිහිල්ලා ඒ අදාළ parties වලට දඬුවම් කරන්න. බෙදලා because it becomes a legal document.
Sir,
Yes, oh, yes.
දැන් ඔය collective agreements අත්සන් කරනවානේ.
Oh,
අත්සන් කරලා පස්සේ දැන් ඔය circular එක හැමෝටම ප්‍රදර්ශනය කරන්න ඕනේ. එහෙමයි කියන එක.
oh.
එතකොට දැන් ඇග්‍රීමන්ට් එක අත්සන් කරලා පස්සේ ඒක යූනියන් එකයි ආයතනයයි තියාගෙන ඒ කියන්නේ ඒතර හැම සේවකයෙක්ටම දෙන්න ඕනද නැත්නම් අදාළ රිලෙවන්ට් ඩිපාර්ට්මන්ට් වලට දුන්නා නැද්ද?
මෙහෙමයි trade union එකට අනිවාර්යෙන් දෙන්න ඕනේ.
ඔව් ඒක කොහොමද දෙනවා? ඔව්.
The trade union to communicate the members.
ඔව්.
ඒක මෙහෙමයි trade union එකට දුන්නාම ඇති right හැබැයි සාමාන්‍යයෙන් කියනවා ඒකේ terms and conditions notice board එකේ publish කරන්න ඕනේ කියලා. එතකොට හැම සේවකයම දැනගන්න.
ඒක කරදරයි නේද? එහෙම කරන්න ගියොත් එහෙම. එතකොට සං අපේ ඇග්‍රීමන්ට් එකෙන්
අපිට කියනවා කරන්නෙත් නැහැනේ කට්ටිය.
ඔව් ඒක තමයි.
යූනියන් එකෙන් තමයි දැනුම් දෙන්නේ සේවකයන්ට. right
ඔය
collective
කියන්නේ
එකක් තිබ්බ ගමන් මොකද කියන්නේ ඔක අස්සම් කරපු ගමන් යූනියන් කට්ටිය රැස් කරලා ඔක්කොම කරලා සද්දෙකුත් දාලා අපි මෙහෙම දිනාගත්තයි කියලා හරි එහෙම කියනවා. right ඒක එතකොට but employer ටත් duty එකක් තියෙනවා. කවුරු හරි කෙනෙක් complaint කළොත් එහෙම මේක භාෂා 3ෙන් දැම්මේ නැහැ කියලා ඒක අනවශ්‍ය කරදරයක්. කොහොම හරි ඉතින් මේ ඕකේ තියෙන ඔක්කොම භාෂා 3ෙන් දාන්නත් බෑ notice board එකේ. notice මොකද collective agreement එකේ සමහර වෙලාවට පිටු 10ක් විතර තිබ්බොත් එහෙම ඒක දාන්න බැහැනේ.
පස්සේ සමහර terms එහෙම සිංහල terms එහෙම sorry ඉංග්‍රීසි terms සිංහලට හරවද්දී සමහර ඒවා තේරෙන්නේ නැහැ. ඒ වගේ ප්‍රශ්නත් එනවා සමහර වෙලාවට.
ඔව් ඉතින් මෙහෙමයි. ඕක word to word translate කරන්න ගියාම තමයි ප්‍රශ්නේ තියෙන්නේ. content එක අවබෝධ කරගෙන ඒ content එකේ තියෙන දේ ලියන්න ඕන අනිත් පැත්තට. ඕකේ තියෙන එකම නෙවෙයි. but anyway කොහොම හරි ඕක ප්‍රායෝගිකව වෙන්නේ නැහැ නේ. ඒ නිසා අපි කතා නොකරමු. ඕකට කවුරුන් නඩු දාලත් නැහැ මේ වෙනකන්. හරි.
හරිය.
Yes.
Now, and an employer, by way of incorporating a clause in the bill of appointment, ensure that forming a trade union is not permitted, and if you are found to be involved, the disciplinary action can be taken.
It is not possible. Right? You can't include that kind of clauses, right, in the letter of appointment. Yes, the employer can, but it is not, cannot be implemented. Employer can, say many things. You are not supposed to form trade union or join trade union or strike action. You can, include those terms, right, or conditions in the letter of appointment. One, say for example, the person form a trade union. Then, based on the clause in the letter of appointment, you terminate. But then it becomes illegal term. And you have two cases, not only one. One is the termination. Second one is based on, under unfair labor practices, the employer will be taken into court. There's two cases. One is termination, a case against the termination. The second one, you have terminated person because of his trade union action. So then, right, number 56 of 1999 amendment, Industrial Dispute Act, it comes under unfair labor practice. Right? Unfair labor practices, it is, at the court, if it is proved, only 100,000, right, 100,000, what do you call it, fine, and 1 year, I don't remember the imprisonment as well. Normally, no imprisonment, but fine. But it tarnishes the image, the corporate, image of the company. Right? If you are, say for example, right, export-oriented company, employer, the trade union will write to the buyers. Buyers always try to find loopholes. So when it comes to unfair labor practice, that is more than enough for the trade union to make it, published at the international level. And it has happened, right? The one company here, the very good company, the company is paying very good salary in Fatimaya and some other places. There was no unfair labor practice. Why? Why pause in the political issue? Not during my time. After that, politically, case was filed. Still, the case is being heard at the magistrate under unfair labor. The person lost 20% of his demand. That's you. 20%. There was no unfair labor practice. But something was created. So how but anyway, right? It is prohibited. You can't put, yes, you can as employer, but it is illegal. When it comes to practical situation, if you terminate such person because of his trade union and he form a trade union and others join, get the membership trade union act. So based on the clause that is there in the letter of appointment, highlighting this, quoting this, right? The employer terminates. Then it is illegal. There are two cases against the employer. One is, against unlawful termination. Second, termination as done due to trade union action. Then, if a person is terminated or terminated based on trade union action, then it becomes unfair labor practice. The labor authority will take action against the employer at the magistrate. Even inefficiency එකමදවත් අපිට අහිං කරන්න බෑ. Inefficiency cannot be attributed to misconduct or disciplinary matter. No. ඕවත් පොඩ්ඩක් වෙනස් වෙන්න ඕනේ. මොකද කෙනෙක්ගේ inefficiency එක දිගටම තියෙනවා නම් එයාව තවදුරටත් තියා ගැනීම ඵලදායී නැත්තම් ගේන්න යන්න නැත්තම් ඒක අයින් කරන්න සේවා යෝජකයාට ඉඩ දෙන්න ඕනේ. ඉඩ දෙන්න ඕනේ. දැන් ඔය අලුතෙන් අපි ඇති කරපු the new drafted one we include those. But the employer has to have very reasonable ground to do so. Right? Medical fitness, but the employer then under the drafted plan does not need to come to the labor department, document everything, right? You have proof is inefficient and pay compensation according to the formula and no need of going behind the Commissioner General law. I don't know even that. We have the document because we prepared it and it went up to legal draft. We had a series of consultations with the legal draft. Not me, like our officials. Okay, now, yes.
It's being done. And during the process, the employee applies to another company, he gets an offer and he's trying to move on. Then can this case be continued or what will be the?
Then, if once the worker accepts employment with another employer, the previous employment, contract of employment is breached by the worker. The contract of employment with the previous employer, I mean, the ongoing case. Say, for example,
Say, example, the one for whatever. Employee and so consideration for this, do it. Now, till this is being heard, continuously is getting added. So because of that, he is actually trying to look out and move on to another company. Then.
yeah, a very good example you are taking, I mean highlighting. Unfortunately, then if you accept, because of it's kind of a constructive termination, right? Constructive palanokia palavel. So because of this too much of harassment, the case is being heard at the labor department. Not empty because you have not been terminated. So the case is being heard at the labor department. But say, for example, your promotion has not been given. Continuously, you are being forced to leave the place. Then you find an employment with another employer. Unfortunately, it is fair enough for the worker because he has to, because of the harassment, he is accepting the employment with someone else. Once you work for, I mean, accept the employment with someone else, some other company, there is a chance for the previous, I mean, the present employer to prove that there is no employer-employee relationship. So case cannot be continued. But remember, yes, at that time was there, right? But in law, still this is gray area. We don't have any clear provision. Right? Once when you accept the employment with someone else, we have to understand whether there is no employer-employee relationship. If employer-employee relationship is breached, we cannot continue the case. You understand my point? The employer, when it comes, these legal matters, employer-employee relationship is very important.
So there is a termination branch within the
Yes.
constructive termination.
Constructive termination, then what you have to do is, right? You have to leave the place, right? And vacation of force, whatever, right? Still, then you can prove that you can go to LT or labor department, then you have to I have terminated construct. But if you accept during this period, I mean the case is being heard, you accept employment with someone else. So then what is happening to the contract of employment with the present one? Present one in the sense, if you accept the contract of enter into contract of employment with someone else, your previous contract ceased. So therefore, that is why we included certain provision. Say, for example, as you very correctly pointed out, you are being harassed continuously. Case is being heard here. And even then, you vacate the post. Then it becomes constructive termination. If you vacate the post of the terminate, then you have chance. I mean, you have right to accept the employment with someone else. If termination takes, if there is no termination, you will resign only. Otherwise, while this case is being heard, you don't resign, right? You don't resign in the sense, say like the you accept the employment with someone else, and then what the new employer does? What does new employer do? New not new the current employer, what he does, he is going to do. If you accept the employment with someone else, you are not reporting to work now. You're not reporting to work. You are reporting to work with some other employer. So then automatically the vacation of post.
So otherwise you can say no for yes and then.
Yes, resigning, yes, okay. You resign. Right? You have resigned. Right? If you resign or your employment is terminated, no harm for you to accept the new employment. Right? But case is still being heard. Understand my point? What I'm trying to tell you is if you resign or your employment is terminated, definitely you don't have to worry about it. You can accept the employment with someone else while case is being heard. Right? But without informing here and without informing the resigning, you accept the employment with someone else. Your employment is not terminated, you are not resigning, and then at the labor department, the present employer says that he has breached the contract of employment. So therefore, no point of here in this case. Are you getting my point? Is it clear to everyone? Right. Now the second one, the commission. This is the major one, conciliation. As far as industrial disputes are concerned, conciliation, 90% conciliation. Define, how do we define the conciliation? I have taken something from the website. Define as the settlement of a dispute by mutual and friendly agreement with a view to avoiding litigation, right? Right? Webster's, right? Merriam Dictionary. What does it mean? Look at, define as the settlement of a mutual and friendly. Conciliation mutually and friendly, but with the authority, right? If mediation it facilitates the process. Again, mediation now conciliation, mediation usually neutral third party facilitating the process. But considering with section 3, CGL or authorized officer, CGL means Commissioner authorized officer, after such investigation, as he may consider necessary, take all such steps for including the parties to come to a fair and amicable settlement. That is the duty of the Commissioner Labor Department. Fair and amicable settlement. Who is the facilitator? Labor Department, right? In keeping with the section 3, CGL authorized officer means labor officer after such investigation, as he may consider necessary, right? Take all such steps for including the parties to come to a fair and amicable. CGL, Commissioner General.
Here say fair,
Amicable.
the voluntary arbitration is amicable.
Yes. Because cannot give any order, but any legal proceeding, there are some procedures to be followed. Try to the dispute amicable. Amicable. ඒගොල්ලන්ගේ එකගතා. Right. So the fair and amicable. Fair. ඒක සාධාරණ වෙන්න ඕනේ. කෙනෙකුට අසාධාරණ වෙන්න බෑ. Fair and amicable settlement. Neutral third party. That is, that is not there in the Industrial Dispute Act, but that's
So
a
what I'm
definition.
asking is even in the litigation, also neutral third party.
Yes, it is neutral third party, right? But when it comes to, if mediation, right, usually a neutral third party facilitates the process. Labor Department also doing some mediation part, right? But it can be done by some other party as well. No? Here, when it comes to conciliation, definitely the Labor Department, but Commissioner can authorize someone else. But only labor, no other, word. So, if resolved, Pastor Visudur, under section 12, economic 12.1, section 12 of the IDA, Industrial Dispute Act, a memorandum of settlement, that is called 12.1 agreement in short. Right? Memorandum of settlement shall be drawn up and signed by both parties and sent to the CGL, right? Who shall gazette same if considered a major dispute. Major dispute and the current settlement gazette. Major. Then whether it is gazetted or not, once 12.1 agreement is signed before the Labor Authority, it becomes a legal document. Legal document. All provisions in the settlement 12.1 agreement, all terms and conditions become implied terms and conditions of the contract of employment.
For this stage, employee can either go alone, or employee can even take a lawyer, right?
Yeah, good question. Right. The amendment was brought to the Industrial Dispute Act and some other couple of legislations in 2022. Under the Industrial Dispute Act, the 2022 year, right? The last look at the last amendment, right? 2022. For two matters, I explained only one, right, at the beginning, right, to security deposit. The another one is, at the matters, dispute, if the dispute is being heard at the Labor Department, usually the employer brings lawyer. Yeah, yes, lawyers. But there is no such provision. It says representative. So representative may be a lawyer or maybe a trade union office bearer or some other representative. So because of this one, sometimes, sometimes LT, the main problem was LT. LT presidents always ask the workers, you bring the lawyers. You are supposed to bring no representative. Sometimes they were faster dubbing. The workers have been shouted. So therefore, in order to, address this situation, 2022 amendment was brought. The amendment was brought to Industrial Dispute Act. Okay. At the Labor Commissioner General says sometimes there are no lawyers. Sometimes Commissioner General can refuse. Right? There is no provision. There are some micromedia kilowatt. It part of that. Commissioner General, යාගේ විශේෂ පතයක් තිබෙනවා. නඩුකාරයෙක් එහෙම නෙමෙයි. නමුත් හයි කෝට් ජජ් කෙනෙක්ගේ පවයි. ඒ වගේ වෙලාවක එහෙම හැසිරුණාම Chief Justice will work. That prospect. ඒ පොසිෂන් එක ටිකක් ඒ කියන්නේ රටේ වැඩිම නීති ප්‍රමාණයක් හසුරුවන පොසිෂන් එකක්. නීති 50000ක් වෙන කිසිම කෙනෙකුට එහෙම 50 වල බලයක් ලංකාවේ නැහැ. ඒ නිසා ඒකට ඇයට තියෙන බලය ටිකක් වැඩි. right කොහොම හරි. So no, sometimes the Commissioner General previously, right? Commissioner General may ask, I am lawyer representing, and you can say that. You are not supposed to say lawyer. I am the representative of employer. You may be a lawyer, right? So this ambiguity was there. LT, when it goes to the LT, always LT presidents ask the worker to bring lawyers. So therefore, Act was amended. At the LT, from the work of employer, the representative from their trade union can attend, right, on behalf of a worker at any, equally as lawyer, right? Now, most of the intercompany, those are, the trade unions are represented. At the same time, at the Commissioner General, when conciliation takes place, lawyers can act. Both lawyers and representative can act. And the LT also say now.
So, at LT, can't you represent yourself?
Yes, why not? But it's not happening always because
Say, I'm a lawyer. I can do the
yeah, there is until unless there is no objection from the LT president, I don't know about that, but you can. And then උසාවි වලට ගිහිල්ලා අපි අනුකාරය නැතුව තනියම කතා කරන්නේ. තනියම කතා කරන්නේ. එහෙම නැතුව. පුළුවන්. එහෙම වෙනවා very rare. කවුරු එහෙම කතා කරලා තියෙනවා මුල් දැන් මේ කාලේ නෙමෙයි. මුල්ම කාලේ. රෝහණ විජේවීර. අත්තේක නඩුවේදී. අත්තේක නඩුවේදී එයාම තමයි කතා කළේ. හැබැයි බාලසම්පෝ එහෙම පස්සේ මේවා කළා. Who take get CMU. But anyway, you can. So that is another, the reason for the amendment 2020, right? So once it is signed, right? Section 14, every settlement is binding on the parties. Who are the parties? Who are the parties? Parties to the dispute, employer and the worker. Right. The terms of the settlement shall be considered to be implied terms in the contract between the parties. Parties may repudiate settlement by written notice to the CGL and other parties. කෙනෙකුට settlement 12 එකෙන් අපි අයින් වෙනවයි කියලා. So it can be informed to the commissioner and the other party in writing. And even because there is that right has there because the settlement, right, become the legal document, right, and it can be repudiated, right. සේවා යෝජකයාගේ පැත්තෙන් පුළුවන් workers like but it has consequence. Repudiation, yes, you can. If some other party, due to employer, right, will not adhere and inform the commissioner, okay, we are repudiating. And then, if other party complain, the labor authority take legal. If other party complain, repudiation, right? You have repudiation, right? Next, procedure for conciliation. Memorandum of settlement of the dispute to be signed by both parties. This is commonly known as Section 12(1) settlement or 12(1) settlement. In the event of the commissioner or authorized officer cannot settle dispute, he is to prepare a full report on the steps taken by him to settle the dispute. ඒ report එක commissioner යවන්න ඕන. Commissioner General. එතකොට තමයි යා තේරුම් ගන්නේ මේක whether refer for arbitration or not. Right? Full report. Binding effect of 12(1) settlement. What are the binding effect? Right? Section 14 deals with validity of settlement by conciliation made under Section 12(1). Every settlement which is for the time being imposed shall be binding for the purpose of the Industrial Dispute Act on the party. Trade unions, employers, and workmen referred to in that settlement as parties, and the terms of the settlement shall become implied terms of the contract of employment between the employers and workmen bound by the settlement. We already discussed this one. And then let me give you a classic example. Supreme Court appeal number so and so, Jayasundara versus Next Manufacturing, very recently 1,200 employers were terminated, were closed, right? Terminated. The case you might have heard about it. Next again, again, where we? And then that's the problem. Say, okay, that's Sarasiya. Edit that. Sorry? About Wahan the bag. Well, one. Because speed will be Wahu, hey, you put available on it. One of them, you know, make to one the bag. You don't know what it is that you will how it doesn't make it every day to just immediately before department take legal action against the company has can go to what you call liquidation process. Liquidate තත්පර ගවම අනිත්‍යව යන්න බෑ. එතකොට liquidation එකේ මොනවද ඉස්සෙල්ලාම කියන වත්කම් ටික විකුණලා ඒව ඉස්සෙල්ලා loan එක ඉස්සෙල්ලා කියන බැංක් ඊළඟ second එනවා EPF ETF පැතිතිය වයිද වන්දියන්නේ තාක්ෂණික මොනවද ඉක්ුණොත් වන්දියන්නේ මොනවද ඉක්ුණොත් පිට I think all of directors like වත්කම් වලින් ගෙවන්න වෙනවා තමයි. අර liquidation process එකේ ඒගොල්ලෝ අත්පය කරලා liquidation එකට ගියොත් උතන නෙමෙයි ඉතින් ඊට පස්සේ නඩුවක් වෙනවා. තාර්ක කරන්න පුළුවන්. board of directors වග කියන්න ඕනේ ඉන්න කාල. උඹත් බංකොලොත්. එහෙනම් ඉන්නේ company බංකොලොත් කියන්නේ board of directors ලා බංකොලොත් නෑ. එන්නම් පුළුවන් නෑ. ඉවත් වෙනවා එහෙනම් අපි නඩුවක් දැම්මොත් නෙවෙයි ඒක ඩිපාර්ට්මන්ට් එකේ නඩුවක් දැම්මොත් නේ ලයබල් වෙන්නේ board of directors ලා liquidation එකේ කියෝ board of directors ලාගේ වන්නේ එහෙනම් අපි නඩුවක් දැන් ලේබර් ඩිපාර්ට්මන්ට් එකේ නඩුවක් දැම්මොත් මොකද වෙන්නේ board of directors ලා ලයබල් ඒක තීන්දුව දෙන්න පුළුවන් ඒගොල්ලෝ ලයබල් කොහෙන් හරි ගෙවන්න ඕන නැත්නම් ඉර යන්නත් පුළුවන්. මොකද ටර්මිනේෂන් ඇක්ට් එකේ විතරයි තියෙන සෙක්ෂන් ඒ කියන්නේ අර අවසරයක් අන්න ඉල්ලීගල් ටර්මිනේෂන් එකක් වුණා සෙක්ෂන් 2 එකට වැටුනොත් එහෙම කියන්නේ ඒක ප්‍රොසීජර් එක ෆලෝ කරලා තිබුණ නැත්නම් ඉම්ප්‍රිසන්මන්ට් විතරයි. ගඩ නැහැ. ඒක ඇද. හරිද? ඒ නිසා බෝඩ් ඔෆ් ඩිරෙක්ටර්ස්ලා තියෙන එකක් හරි විකුණලා හැබැයි ලික්විඩේෂන් ප්‍රොසෙස් එකට ගියොත් කම්පැනි මාදන්නාතර liquidation මොකද ඒක අපේ විශේෂපත්යෙන් වෙනස් එකක්. liquidation එකේදී මුළු පිරිසුලගේ වත්කම් වලට විකුණන්න යන්නේ නැහැ. කම්පැනි වත්කම්. ඉතුරු වෙන එකෙන් තමයි අර ටික බේරලා ඊට පස්සේ එනවා ETF, ETF, validity, but compensation පල්ලෙහා. ලිස්ට් එකේ පල්ලෙහා. ඒ ලිස්ට් එක. is it මොකද්ද? ඔය ඉතින් ලික්විඩේට් කරන මොකෝ මම වෙන්නේ නැහැ. තමයි ට්‍රස්ට් දෙන්නේ. එතකොට එහෙනම් කම්පැනියක් ලික්විඩේට් කරන තැනට එනවා කියන්නේ බංකොලොත්. එහෙනම් මේ බංකොලොත් භාවය වේලසමින් අඳුරගෙන බංකොලොත් භාවය අඩු වෙන තැනකදී ඒක වහන්න ඕනේ. හරි. ඒව කියන්නේ අන්ති දීලා හරි මොනවා. අනිත් එක බංකොලොත් වෙන්න අවදියවල් බලපාන්න පුළුවන්. බෝඩ් ඔෆ් ඩිරෙක්ටර්ස් ලගේ තියෙනව බලපාන්නත් පුළුවන්. වෘත්තීය සමිතිය බලන්න. වෘත්තීය සමිතිය ක්‍රියාමාර්ගයෙන් වෙන්න පුළුවන්. එතන එහෙම එකක් තියෙනවනේ අපි ඉතින් නම් ගලක් කියනවා. එහෙම කේස් එකක් තියෙනවා. ඉතින් ඒක නිසා මේ මේක තමයි සිටුේෂන්. රටක් අපිට තියාගන්න රටක් හැටියට දියුණු වෙන්න නම් ගොඩක් දේවල් වෙනස් වෙන්න ඕනේ. සේවකයෝ බල්ලෝ බලල්ලෝ වගේ එළියට දාන කම්කරු කීතියක් අපිට ඕනේ නැහැ. හැබැයි කාම්පුතාට හිරේ යන්න වෙන කම්කරු නීතියකුත් අපිට ඕනේ නැහැ. බිස්නස් ප්‍රොමෝට් වෙන්නේ කොහොමද? ප්‍රොමෝට් කරන්න ඕනේ කොහොමද? ඒක රටේ සමස්තය මත තීරණය වෙනවා. රටේ සමස්ත සමාජ කියන්නේ මැක්‍රෝ ඉකොනොමික් සිටුේෂන් එක හොඳ නැත්තම් රටේ ආර්ථික වර්ධනයක් වෙන්නේ නැත්තම් බිස්නස් එන්නේ නැත්තම් ආයෝජකයෝ එන්නේ නැත්තම් එම්ප්ලොයිමන්ට් එක ඇති කරන්නත් බෑ. හැබැයි ආයෝජකයන්ට එනවයි කියලා ඇවිල්ලා මෙහි ව්‍යාපාර කරලා කීයක් හරි හම්බ කරගෙන යුකයන්ට අමාරු වෙලාලා යන ආයෝජකයෝ අපිට උනේ නෑ. එහෙම ආයෝජකයෝ නොයන තරමට හොඳයි. ඉතින් මේ දෙපැත්තක් තියෙනවා. මම දන්නේ මොකද that is not my area. හරිද? කරන්නේ දැන් මෙහෙම ගන්නකො price star apparel කියලා එකක් කොහොමද කරන්නේ? ඒක කී දෙනෙක් අනාථ වුණා. කුමාර දේවපුර කී දෙනෙක් අනාථ වුණා. උන්වහන්ගේ පුතා තමයි අන්තිමට නාටු 1000 ගණන් තියෙනවා. අද 1000 ගණන් තියෙන දැන් ලිපිට අපි දෙනක් නෑ. මම ඉතින් පුතාලා ඩිවිෂන් එක අරගෙන කොහේ හරි මොකක් හරි ගියා අරගෙන ඩිවිෂන් එකේ වෙයි මොකක් හරි. ඉතින් හතු පිපෙන්න ආවේ දැන්. රට හැමදාම. ඕ ඊවල හරියම එක්ස්පෝර්ට් තිබුණා ප්‍රශ්න. ඒ උඹ කරන්නේ. ඒක නිසා දැන් අද ඔව් වෙලුණත් එහෙම වුණා. වෙලුණ එහෙම වුණා. ඊට පස්සේ තව SQL එක වැහුවා. සල්ලි SQL එක අය මෙහෙ කොයිද නම්බරක් තිබුණා. ඒවා මේ පතු කියලා හරි. ඒක වැහුවා. වැහුනේ වන්දි දීලා වැහුවේ. වැඩි වන්දියක් දීලා කිව්වේ. ඇයි? ඒ කියන්නේ වල කියන්නේ නැතෝ. ඒ කියන්නේ හැමදාම ස්ට්‍රයික් කරනවා, උද්ඝෝෂණය කරනවා, ප්‍රොඩක්ෂන් එක දෙන්න විදිහක් නැහැ. මේ මිනිස්සු නෝ වන්දි මොකද සේවකෝ කැමති වුණා දෙන්න තුන් දෙනෙක් අකමැති වුණේ මම හිතන්නේ. මොකද ටිකක් ලොකු වන්දියක් කම්පෙන්සේෂන් ප්ලස් ඒ කියන්නේ ෆෝමියුලා ප්ලස් තව ටිකක් දුන්නා. ඉතින් ගිහිල්ලා අපේ මිනිස්සුත් කරන්නේ ස්ට්‍රයික් කළා අහගන්නවා වන්දි අරගන්නවා පහුවදා වෙන එකක් හොයාගන්නවා. සෙෂන් ගවර්න්මන්ට් එක. මේක තියෙනවා. පහුවදාට ඉතින් අනිත් පැත්තෙන් තව දෙයක්. තව එකක් තමයි so another pathetic situation. Most of the companies now, because of this the trade union action, they are hiring people from manpower company only for 1 month. Another set of workers for another month. Today, the lady works for Sumanavati and company, right? Next month, Siddhidasa and company. So tracing them is very difficult. Violating the payment of EPF, and then taking I'm not blaming only for trade unions, the employers as well. They are not genuine people. But there are genuine people, genuine companies. Sometimes problems are created at genuine companies. So we have to understand this, I'm not saying this is correct, this is right, this is wrong. I'm explaining, I'm sharing my experience. Okay, well, so this is the case, right? Supreme Court appeal. So Jayasundara next 2000, right? When the matter is settled under section 12(1) of the IDA, Industrial Dispute Act, the labor tribunal has no jurisdiction. Most of the time, sometimes workers are reporting the termination to the labor department. Labor department try to settle amicable dispute immediately. So worker sometimes agree, okay, to settle this, taking some compensation. They sometimes maybe less than the compensation for me. But settle. The worker agreed, employers also agreed. Signed MOU, remember, memorandum of settlement, 12(1) agreement. Later, a couple of months later, they go to LT. I was terminated. I approached to sometimes, to the labor department, but it was signed by post. My signature was taken by post. That may be, then the LT entertained. Sometimes the person hides, right? The history. He never say it was settled under the labor department. The case is, filed. Sometimes without even this LT president, they don't have much role and knowledge with regard to labor law. They are just doing the termination part one. The labor law, not only termination, it has some the connection with other laws as the labor employment laws as well. So they entertain it. It happens. So then the employer goes to Supreme Court until Supreme Court. The Supreme Court asks very clearly the case is the next manufacturing decided on so and so. When the matter is settled under section 12(1) of the IDA, labor tribunal has no jurisdiction to entertain. So this is concrete now. In order to change, this is the latest. So no judicial high court, provincial high court or the labor tribunal ignore this. Cannot ignore, because it has come from the top. In order to change this situation, this was a three bench one. And then, someone has to appeal this decision against this decision, again as the Supreme Court, but the decision should be given by 5 bench. Yes. So this. Yes.
Done. So from this, so it cannot be have a jurisdiction under any court. So in provincial LTO in another court. So by repudiation, what the authorities can do.
Repudiation is something else, right? Once it is settled, the parties, the worker or trade union, the employer can repudiate, right? In writing to the conditional right? So, if it is repudiated, the affected part can go to court. Right? So, collective agreement was violated, right? Under the, when we, intervene into what we call this, plantation sector collective agreement was in existence, right? So the wages were increased under the wages code, summoning the wages code. The clear violation of the provisions of the collective agreement. That is why employer went to court. Some party can go to court. Okay, is it clear? Sure. That they can, but normally, again, sometimes, it comes as, again, dispute, right? Instead, going for court, comes as, again, dispute. Okay. But 12-1 is once it is done. 12-1 is not collective, right? The settlement of, right, memorandum of settlement. So once it is settled and signed by the parties, no party has, can go to, the court against the whatever.
But unless the exception would be, I think the party can say that under this, so it would be, we have to sign it, something like that.
They can, but with this decision, where is the place to go to? If there is, say for example, 12-1 agreement, right? Worker, not the employer, 12-1 agreement, the worker can go to, right? Where is the place? The place that the worker can go? It. Right? My termination, my employment was terminated, right? But however, it was conciliated and 12-1 was signed by force. Even though he said such thing at the LP, what does this code decision say? No LP. You can say many things. 12-1, you can't say that by force because it is signed on behalf of the labor, in front of the labor code. LT has no jurisdiction for any matter related to 12-1 agreement once it is signed. But here it is 12-1 එකක් ගැව්වා කියන්නේ ගැව්වම තමයි. ආයි ඒකට එරෙහිව සේවකයෙකුට LT ගිහිල්ලා වෙන වෙන කතන්දර කියන්න බෑ. කවුද කියන්නේ? මම නෙමෙයි. සුප්‍රීම කෝට්. එහෙම නෑ. ඔතෙන්ටිකේට් කරනවා මේ පොත් පොත. කරන්නත් පුළුවන් අපරාධ. Yes. You have any question?
Just so that means so we can see only under LP, but not any other courts. So because of that, so the 12-1 is signed, so that's it. So if that's it, any other.
Let me take this one. 12-1 is signed for what? 12-1 is signed for what? To settle the dispute. Right? What are the elements of dispute? Employment, non-employment, terms of employment, conditions of employment, right? And termination of employment. When it comes to termination, right? If say terms of employment, there is no point. There is, once it is settled, non-employment, employment, non-employment, terms of employment, conditions of employment. Once we sign, there is no place for you to go. You can't go to magistrate court. either for employer or worker. Again, you can lodge a complaint with the labor department. Again, conciliation, right? But when it comes to termination, 12(1) can be fine, right? How? Termination has taken, right? Worker lodge a complaint with the labor department. Employer and the worker are summoned, labor department summoned both parties. And instead of just taking, the legal action against the employer, filing case with the magistrate court, at least 1-2 times, try to whether there is a possibility to settle this. Because termination comes under the definition of industrial dispute. Okay? You have to understand the principle, not just the principle is termination comes under the definition of industrial dispute. So, dispute always try to be settled through conciliation. So, therefore, maybe 2 times maximum, labor department tries to settle. Workers also agree. Okay, employer says, I will compensate this amount. Workers say, sometimes no, I need this amount. So, as a result of negotiation, come to amicable settlement, sign both parties, to authenticate by the labor authority. Later, only for termination matter, right? The worker used to go here settle. After maybe couple of months later, we have experience, right? Worker, they go to LP and say, my termination, I was terminated, but it was settled at the labor department, but my signature was taken by post. Sometimes he never mentioned about the labor department, and lodge a complaint. Before 6 months. And without referring anything, sometimes communicate in the labor department. The tribunal may entertain, right? And as company is in existence, ask the employer to reinstate. Already has been settled under 12(1). And then against the decision, the employer in this case next went to the provincial high court. Next step, provincial high court affirmed the decision of the LT and the reinstate. Then next went to court of Supreme Court against the decision of the LT, and it was affirmed by the provincial high court as Supreme Court said 12(1) is 12 months settlement. Once it is settled, LT has no jurisdiction. Okay, cannot intervene. So 12(1) is so powerful because the amicable settlement. Okay, got it? Right. Next. Oh my God. But the repudiation of settlement. Look, repudiation settlement by the contracting parties giving notice to the commissioner in writing and also noticing every other party. Section 15(2), where valid notice of repudiation of a settlement was received by the commissioner, the settlement shall, right? The settlement shall terminate and cease to have effect upon the expiration of the monthly immediately succeeding in the month in which the notice is received by the commission. Again, repudiate කරන්න මේ මාසේ දුන්න නම් කමිෂනට ඊළඟ මාසේ ඉඳලා තමයි මාසයක් ගියාට පස්සේ තමයි ඒක ඉෆෙක්ට් වෙන්නේ. බලපෑම එන්නේ. Right. Method of settling the dispute by the commission. Look at complaint received by the commission. There are 2 baskets. We can put those complaints or disputes into 2 baskets. One is right, statutory rights, gratuity, EPF, salary. These matters cannot be conciliated, right? Because the clear violation of the law. These are Non-static, right? What? Increments, right? Termination benefits. This is not seva, like some other benefit, right? Promotion, bonuses. So those are real disputes. So once, conciliation, it goes to termination unit and arbitration as well. Right. This is, in nutshell, the method of settling the dispute by the commission. If it is, the termination, it goes to the termination branch. Mostly the conciliation, otherwise arbitration. Okay. Enforcement mechanism. Right, look. Dispute arises. Settlement by the commissioner. Conciliation. If failed, voluntary arbitration. Voluntary arbitration. The matter will be referred for voluntary arbitration. And the award will be granted. Arbitration and industrial courts are given award. Award. Right? The commissioner also give kinds, just one second. So, hello. 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 Oh, what are you doing? Boarding so the settlement by the commissioner. If commissioner, the labor authority fails, matter will be referred to arbitration. This is not compulsory. This is voluntary arbitration, right? Award will be granted. Right? Even say arbitration, this can be included for whatever the compulsory arbitration as well. Oh, arbitration means either voluntary or compulsory arbitration. Compulsory by the means the arbitration. Arbitrator is giving an award, not order. Order. Right? Against the award, either party decision against the awards and the decision. Decision, who is giving decision? Labor authority. Right? Labor authority is giving decision. Arbitrator and the industrial court are giving what? Award. Right? Either party can go to directly court of appeal against the award and decision. LT gives an order. Right? In order to, against award, not writ, right? Appeal procedure, appeal, right, at the provincial high. Right? Award decisions and award against decisions and awards. Employer or worker against that, the award and decision directly can go to court of appeal and the Supreme. Orders are given by against LT, not directly to the court of appeal, but directly to the provincial high court and then Supreme Court. Okay, right. And then award. If not complied, what? File the case in the magistrate court by the commission in order to implement the award. In order to implement the award. And then at the magistrate court, on conviction, fine up to rupees 5,000, imprisonment up to 1 year or both. Right? However, the employer or either party against the award can directly go to writ application, file the writ application at the court of appeal. And again, if decision does not come in favor of the person who go to, and again appeal to Supreme Court. Appeal to Supreme
So yeah, I think that when you the and in the Supreme Court, that part is already taken by the lawyer.
Court mostly.
But
Mostly employer. 100% employer. But either party, here is either party can go. Okay. But normally, almost 99%, writ by the employer. And to appeal to Supreme Court. Okay. The Supreme Court gives an order or decision in favor of employer. Oh, I mean, the who has, went to the court of appeal, then the finish. Penalty is unfortunately, the employer goes to Supreme Court. Supreme Court gives a decision against the employer. Right? Then this award becomes active. In order to so therefore, the Supreme Court decision in favor of, the affirm the award. Again, in order to implement the decision of the Supreme Court or this one, the labor authority has to go to magistrate. In order to implement the award, I mean, the decision of the Supreme Court. Supreme Court के हम आवाज़ ही लगा है, implement करेगा ना आये अन्नों को कहते हैं, look, what is this? The cumbersome exercise. If it can be said to within 5-6 months, we usali improve. Okay.
Something practically went there, whatever the name employer agreements.
ගෙවන්නෙත් නැහැ. ගෙවන්නෙත් නැහැ, රිට් යන්නෙත් නැහැ. Either, I mean, scenario, right? Either you can go to, I mean, the employer goes to, he goes for court of appeal means they are, they are not adhering or they are not accepting the award. Not accept. Some employers, what do they do? Neither go for court of appeal, no adhering to the award. They come and right? They come and award එක දීලා මේකට යන්නෙත් නෑ මේකට යන්න. Within normally 30 days award එකට මොකද කරන්න ඕනේ? Comply. නැත්නම් labor authority එක මොකද කරන්න ඕනේ? Magistrate court එකට යන්න. තවද type by එකට අහු වෙනවා කියලා notice කරලාවලු තියෙනවා. 30 days. Let me check. Come back to you. If I'm not mistaken, 30 days. I will check and let you know.
5,000 එක farm by
Over 500. 500. Next. So arbitration. Next one. Two forms. Voluntary arbitration. Right? And compulsory arbitration. Voluntary arbitration. Parties on their free will submit the industrial dispute to the arbitration through the Commissioner of Labour for settlement. And Section 3(1)(d), Commissioner of Labour to refer the industrial dispute for settlement by an arbitrator if the parties to the dispute consent to do so. That is voluntary arbitration. Okay? Is it clear? Right. Voluntary arbitration referred to by the Commissioner General of Labour with the consent of the parties to the dispute. Compulsory arbitration referred by the Minister of Labour to maintain industrial peace where parties are required to resort the status quo pending a decision. Right? In order to, the minister, he doesn't care about the consent. Compulsory means by force, right? So, required to resort, because, I mean, then we come to, if there is no solution, comes to deadlock situation. If it is a strike, the status quo means no strikes, cannot continue. Once it is referred for compulsory arbitration, whatever the arbitration, cannot continue the strike. An employer must allow the workers to come to work. That is status quo situation. And voluntary arbitration can be a person agreed by the parties, or if not, nominated by the CGL. Terms of the tribunals drawn up by the CGL and arbitrator is limited to matters arising out of such tribunal. Arbitrators in a limited scope. ඒක හරියට කමිෂනර් ජෙනරල් ලියලා දෙන්නේ. දාන එකේ තියෙන ආරවුල මොකද්ද? පොළ තියෙනවා 20 ගානක්. We are very important when we are referring a matter for arbitration. The definition of the dispute is very important. සමහර වෙලාවට අපේ කමිෂනර්ස්ලා ලියන ඒවා වැරදි. ආර්බිට්‍රේටර් දාන්න එනකොට කමිෂනර් ජෙනරල්ට අනිවාර්යෙන් එනවා, සෙක්‍රටරිට එනවා අනිවාර්යෙන්. මොකද කම්පල්සරි ආර්බිට්‍රේෂන් දාන්නේ මිනිස්ටර්ට දාන්න බෑනේ, ඩිරෙක්ටර් කමිෂනර් ජෙනරල්. මිනිස්ටර් දාන්න ඕන සෙක්‍රටරියට. ඒ සෙක්‍රටරි අස්සම් කරන්න තියෙනවා කොළ 15ක් විතර. ඒකේ මම හැමදාම කියවන එකක් තමයි ආරවුල මොකක්ද. ආරවුල වැරදුනොත් අවෝඩ් එකක් වැරදි. Right. Arbitrator can decide that the matter is not an industrial dispute. Yeah, industrial dispute එකක්ද නැද්ද කියලා කියන්න පුළුවන්. ඒක arbitratorගේ වැඩ. But arbitrator must make all inquiries as may be considered necessary. අවශ්‍යයි හැඟෙන ඒ දේවල්. Must make an award that is just and equitable. යුක්තිය හා සාධාරණත්වය මත පදනම් වූ තීන්දුවක් දෙන්න ඕන. Good. So now I'm bringing it for lunch. What about 1 o'clock? Okay, at once, right? So I'm breaking it for lunch. Come back at 1 o'clock. What do you think? Is it interesting or not? presentation එකක්. So, ladies and gentlemen, I'm going to start. Participants from the Zoom online. There is a message. What is that? Please, diploma, please. Right. Well, right. Let's start. Arbitration. Right. We discussed this one. And the next. Right. Well, powers of the minister in settlement of dispute. Section 4 of the Industrial Dispute Act. This is compulsory arbitration. Right. So, look at the labor industrial court also comes under the compulsory arbitration. Right. It is not separate court, but it is a separate entity. But little high, with persons with high caliber, they are appointed on the basis of the recommendation of the Minister of Labor. The President appoints maximum 10 for 3-year tenure, right? If the dispute is major dispute, just an arbitrator, instead of one arbitrator, selecting 3 personal arbitrators from the industrial court, the matter will be referred for them. It's about the gravity of the problem, right? The dispute. Well, this is the minister, the only thing that the minister has power to settle industrial dispute. This is called compulsory arbitration. Either refer the dispute to an arbitrator or labor tribunal for settlement, or if the matter is dispute is major, it is referred. The dispute is referred to the industrial court for settlement. Settlement. Remember? Settlement. Okay. Reference to arbitration. Commissioner of Labor is to prepare specific reference, unambiguous, for arbitration. The dispute, the definition of the dispute, when the labor authority writes it, it has to be very clear. Always, the higher authorities, Commissioner General and the Secretary, when it comes to the compulsory arbitration, CGL has to prepare all documents and send it to the Secretary, to the Ministry, line Ministry. And Secretary knows the subject. If the Secretary knows the subject, they will definitely go through entire document, as I did. But the entire, the new one, who doesn't know anything about labor law, CEO, he will sign or ask someone what is it, and it had happened, right? During, couple of, previously, a couple of people appointed, some secretaries were appointed out of the service. I mean, service in the sense, not from the labor, they don't have any knowledge about the labor law. So, but anyway, I was very careful, right? And with regard to the definition, because, mistake was done by me. One matter, fortunately, it was turning back, right? One matter, at the last, couple of months before I retired or resigned, 2024, maybe March or April, May, I received what you call this matter to be referred for arbitrator. Arbitrator is, named by the Commissioner General, and there are a lot of documents, right, referring to arbitrator and other parties, to both parties. And I was, very careful. I do not look at any other thing, but I very carefully look at the dispute. ආරවුල කුමක්ද යන වග කෙටියෙන් සඳහන් කරන්න ඕන. Right? The dispute must be defined very precisely in short. ඒක තියෙනවා පොඩි පැරා එකක් තියෙනවා. So when I was reading it, I realized that it's ambiguous. Those ambiguous. ඒකේ අහන්න මොකක්ද දන්නවද? මොන ස්ට්‍රයික් එකක්ද? ඊළඟේ ස්ට්‍රයික් එක. ස්ට්‍රයික් එක වෙලාවේ මේ ස්ට්‍රයික් මැටර් එක then නවත්තන්න නම් මොකද කරන්න ඕනේ? In order to stop the strike, matter should be referred to arbitrator. Once it is referred to an arbitrator, no strikes to be continued. Employer should allow the workers to come to work. What we call a status quo situation, which was previously before strike. So then, when I was reading it, it says something else. ඒක කියන්නේ සිංහලෙන් මම කියන්න ඉංග්‍රීසියෙන් කියනකට වඩා ලේසි එකක් තිබිච්ච wordings එක. මේ වෘත්තීය සමිති ක්‍රියාමාර්ගයේ හේතු කොටගෙන ආම්පුතා විසින් සේවා යෝජකයා විසින් සේවකයන්ට යම් අසාධාරණයක් සිදු වේද යන්න ඇද්ද යන්න. ඒ කියන්නේ ස්ට්‍රයික් එක වෙලාවේ මේ මැටර් එක ස්ට්‍රයික් එක කියන්න ඕනේ. Strikes going on, no settlement at all. So therefore, this matter will be referred to an arbitrator to give an just and equitable award. ඒ වෙනුවට ලියන්නේ සේවා යෝජකයා විසින් ඒ ස්ට්‍රයික් පීරියඩ් එකේ සේවකයන් ඒ ස්ට්‍රයික් කිරීම නිසා සේවා යෝජකගෙන් යම් අසාධාරණයක් සිදු විය. ඒ කියන්නේ ස්ට්‍රයික් එක නෙමෙයි ඒක කරන්න නෙමෙයි වෙන ඒකත් එක්ක වෙන ප්‍රශ්නකුත් ආවා. So then I realized I set aside the file. However, later, without I mean, just I had lot of work, so I set aside file, but අර අනිත් file ගොඩක් මේකත් ඔක්කොම එකට තියලා ඉතින් බැලුවා. So it went to the මේ සමිති කට්ටිය ලිස්ට් එක පැත්තට ඇවිල්ලා ලිස්ට් එකට කියලා මේක අස්සම් කරගෙන ගිහිල්ලා අස්සම් කරවගෙන ඒකට ෆයිල් එක යනවා කමිෂන් දෙන්න. ගියාම both parties වලට මොකද යන්නේ? මේ dispute එක මෙහෙම ආර්බිට්‍රේටර් රිපල් කරා මෙන්න dispute එක මෙව ටික ඔක්කොම යනවා. Fortunately, the person, the arbitrator, whom the matter was referred, he declined because of his other engagement. He declined. The file came again, nominating another arbitrator. Then I realized that I put a note to the minister that previously, yes, we have, by mistakes, we have referred this one, but however, the person has declined it, the arbitrator. Now, when I read this, what do you call it? The matter now workers are working, the employer has allowed workers to come to work, so there is no more strike, so therefore, no need of referring this matter for arbitration. The minister, okay, let's finish. කියන්නේ සමාජය ලියනවා සමතාව යූනියන් මං කියන්නේ මේ යූනියන් එක වැරදි කියලාම නෙමෙයි ආ සමහර යූනියන් ඉන්නවා ප්‍රශ්න හදන්න ඕනේ හින්දා අපේ අය ගිහිල්ලා කොහොම හරි ඩිපාර්ට්මන්ට් එක අතුරනවනේ ඒගොල්ලන්ට ඕන විදිහට මේක ලියා ගන්න ඩිස්ප්ලින් රයිට් ඒ උනාන ඒක එහෙම උනාන ඒක ඊට පස්සේ මෙන්න ආර්බිට්‍රේටර් දාලා තියෙන්නේ ස්ට්‍රයික් වෙලාවේ ආපුතා ක්‍රියා කරපු ආකාරය සම්බන්ධයෙන් හොයන්න කියලා ඉන්ටර්නැෂනලි දෙනවා එහෙම කෙනෙක්ගේ ස්ට්‍රයික් මේකකට තමයි ගියත් fortunately no strikes, so there is no need of referring the matter to an arbitrator. Kumari right. So minister has to prepare right. So the commissioner matter that should be determined should be clearly spelled out. Section 16 of the commissioner's statement. ආරවුල කුමක්ද යනවද? that is ඔයාලට එහෙම එකක් ආවොත් යූනියන් පැත්තේ හරි ආම්පුදාගේ පැත්තෙන් හරි ආරවුල මොකක්ද කියලා බලන්න. ආරවුල තමයි කියවන්න ඕන. අනිත් දේවල් වැඩක් නැහැ. Right. Well. Section 17 procedure for arbitration. Arbitrator assume jurisdiction on referral. Arbitrator has some jurisdiction, right? Take steps for preparation of the case for hearing. Case එක අහන්නයා prepare වෙන්න. Arbitration here such evidence, right? Arbitration here such evidence as may be, right, tendered by the parties to the dispute and make a just and equitable award as may appear to an arbitrator. Both parties වලට අවුකම් දෙන්න ලිඛිත දේශන, ලිඛිත දේශන, වාචික දේශන මේ ඔක්කොම තියලා අහලා ප්‍රශ්න අහලා දෙපැත්තක සවන් දීලා just and equitable decision එකක් දෙන්න ඕනේ arbitrate. සමහර arbitrators ලගේ ඕඩ් වැරදි. අපි ගෙන්නලා කියනවා මොකක්ද ලියලා තියෙන්නේ මාපව වෙනස් කරලා ගියේ. සමහර ඒවා ඒ කියන්නේ මොකවත් නැහැ. decision එකක් නැහැ. ඒකට කරේ නැත්නම් උසාවියේ ගිහිල්ලා ක්‍රියාත්මක කරන්න. ඒ නිසා එහෙමත් ඒවා තියෙනවා. Well, repudiation of an arbitrator, award made by an arbitrator. Repudiate කරන්න පුළුවන්. repudiate කරන්න, repudiate කියන්නේ ප්‍රතික්ෂේප කරනවා. එහෙනම් මොකද්ද ප්‍රතික්ෂේප කළා කරන්න ඕනේ? ප්‍රතික්ෂේප නම් against නම් යන්න ඕන කොට පැකිට. එහෙම නැතුව නිකන් හිටියොත් මොකද වෙන්නේ? Labor Department should take action, filing the case with the magistrate court within 1 year reasonably. There is no timeline, but the practice is within 1 year from the date award was granted. Award එක දීපු දවසේ ඉඳලා අවුරුද්දක් ඇතුළත Labor Department එක ඒක බලාත්මක කරන්න, impose කරන්න should go to the magistrate court. Right. අවුරුදු 5 වුණොත් එයා අමාරුයි. Magistrate ලා විසි කරන්න පුළුවන්. So the Industrial Dispute Act provides that a party bound by an award made by an arbitrator may repudiate the award by a written, this is very tricky, listen very carefully, by a written notice to the commissioner and to other parties. There is no requirement to give any reason for repudiation. However, such repudiation will not have any effect for a minimum period of 12 months from the date of the award. I mean, why is this? 1 year. What award is given today? Tomorrow it will be repudiated by the employer, mostly by the employer. Right? We, the trade union as well. But the effect has there is no effect until 12 months. Complete 12 months from the date of award. Hey, මාස 12ක් යනවා. No effect until 12 months is passed from the date of award. Why? After 12 months, repudiation is accepted. No legal action can be taken after 12 months. 12 months is for what? Within that 12 months, the labor authority has right, legal power to go to magistrate court against the repudiation. මාස 12ක් දීලා තියෙන්නේ ඒක. මාස 12ක් යනකම් you repudiate as an employer. Award. Okay? You can කරන්නේ. Award දෙකලා ඇග්ලිය වෙන්නේ නැහැ. Clear now? We are not in a position to accept the award. It means repudiate in writing to the Commissioner General and the other party. So, even though you say I'm repudiating, repudiation will take place after 12 months. It means after 12 months, this either. Once it is, 12 months, that's up 12 months, what you have, that is accepted. Right? You have right now. But within that 12 months, if the Labor Department goes to magistrate court, the decision will be taken against the repudiation. මාස 12ක් දීලා තියෙන්නේ ලේබර් ඩිපාර්ට්මන්ට් එකට. කොහෙද යන්නද? සාරියට. මාස 12න් පස්සේ තමයි මෙයාගේ repudiate කියන එක පිළිගන්න පුළුවන්. මාස 12ක් යනකම් ලේබර් ඩිපාර්ට්මන්ට් එක නිදාගෙන හිටියොත් මාස 12න් පස්සේ ආයෙ මොකුත් කරන්න බෑ. Repudiation is accepted. Okay? Right. I'm little quick because we have plenty, many slides. Right. Right. Relief that can be awarded by arbitrage. One of the relief. Pradhanaya, one of all wages and all other conditions of service, including for a period of strike or lockout. The arbitrator will decide whether salary has to be paid for the strike period or not, or lockout period or not. Reinstatement or discontinuation, continuance, where termination is in dispute. Right. Echo reinstatement, එහෙම නැත්නම් වන්දි ගෙවන්න නියම කරන්න පුළුවන්. A gratuity, except if the gratuity is due under the Gratuity Act. Gratuity Act නම් අත ගහන්න බෑ. මුලින් කිව්වා ඒක. Gratuity Act එකේ provision එකක් තියෙනවනේ ඒකට බෑ. හැබැයි එහෙම නොවන ඒවා. Right? or bonuses. يعني Gratuity Act එකෙන් පුද්ගලයෙක් ආවරණය වෙනවා නම් ආර්බිට්‍රේටර්ට ඒ දේවල් වලට අත ගහන්න බලයක් නැහැ. Gratuity සම්බන්ධයෙන් නම් ඉෂුව එක තියෙනවා. Gratuity Act එකෙන් ආවරණය වෙන්නේ සේවකව 15ට වඩා වැඩිය. 15ට වඩා වැඩි අඩු ආයතන ආවරණය වෙන්නේ නැහැ. ඒ වගේ ඒවා සම්බන්ධයෙන් ආර්බිට්‍රේටර්ට පුළුවන් මේ award එකේ යම් යම් කරුණු අතුලත් කරන්න. If an order for reinstatement is made, if the workman requests an alternative of compensation, the arbitrator shall do so. But commissioner has no jurisdiction. If the matter is with the Commissioner General, Commissioner General has no power to grant compensation instead of reinstatement if company is in existence. Company තියෙනවා නම් කොමසාරි ජෙනරාල්ට බලය තියෙන්නේ reinstate කරන්න විතරයි. නැතුව මේ වන්දි ගෙවන්න බෑ. හැබැයි arbitrator matter එක refer කරාම arbitrator can either reinstatement or compensation in lieu. Award must be gazetted by the CGL, Commissioner General of Labour. Award can be repudiated by giving notice of 3 months, but repudiation shall not become effective until after 12 months from the date of award of expiration of notice. Right. Or expiry either. Right. Discontinuance means no reinstate. The employment can be discontinued. It means that again reinstatement continuation of employment back wages rate. Even නැතුව discontinuation කියන්නේ ඒක පාරණ වැටුපෙක්ක right CV පිටවන්නේ නැහැ. මෙතන වචනේ කියලා නැහැ. ඒ වෙනුව instead of the compensation ඊළඟ line එකේ තියෙනවා. ඒ කියන්නේ මේකෙන් කියන්නේ reinstatement or discontinuation. කියන්නේ reinstatement එකක් දෙන්නත් පුළුවන්. නෑ reinstatement එකක් නෑ. discontinue කියලා කියන්න පුළුවන්. That is what it means. So this is okay. And industrial court, what is this? The president of Sri Lanka appoints members to the industrial court for a period of 3 years, section 22 of the Industrial Dispute Act. The Commissioner of Labour is to prepare a settlement for industrial court specifying matters in dispute. Who will refer the matter for industrial court? Minister. It is a part and parcel of the arbitration. Is it clear so far? Any question from the participants from online? Okay, well, industrial code continues. Duties and powers of industrial code. What are the duties? In respect of matters referred, to make all such inquiries and hear all such evidence, like arbitration, as it may consider necessary, and take such decision or make such award as may appear to the court just and equitable. යුක්තිය හා සාධාරණත්වය මත පදනම් වෙච්චි award එකක් ප්‍රදානයක් මේක. Award. Review of awards made by arbitration or by industrial court. Review. කොහොමද review කරන්නේ? No appeal lies against arbitrator's award. Appeal lies against industrial court award. Right? No appeal lies against arbitrator's award. Then what? What is the remedy? Go for it. Go for it. Court of appeal. And appeal lies against industrial court award, and that to be heard by an industrial court itself. සේවකයෙක් හරි සේවා යෝජකයා හරි නැත්නම් පාටි එක හරි වෘත්තීය සමිතිය හරි කියන මේ ඉන්ඩස්ට්‍රියල් කෝට් එකට මැටර් එකට රිපෝර් කරපු එකක් නම් ආපහු මිනිස්ට්‍රියට අපීල් කරනවා. මේක අපිට පිළිගන්න බෑ, මට අපිට පිළිගන්න බෑ. එතකොට මිනිස්ටර් ආයි වෙන ඒ ඉන්ඩස්ට්‍රියල් කියන්නේ ඒගොල්ලෝ නැතුව වෙන ආබිටේටර් ඉන්ඩස්ට්‍රියල් කෝට් එකෙන් සිලෙක්ට් කරන් ඒ අයට මැටර් එක රිපෝර් කරන්න පුළුවන්. ඒක තමයි අපීල් කියන්නේ. Right? Are you getting my point? Right. So, for both, judicial review by way of writ is available in the Court of Appeal and then to the Supreme Court. Then make here a අපබ්‍රංශයක් වගේ තේරෙන්න පුළුවන්. Don't misunderstand. No appeal lies against arbitrators award. Arbitrators के award දෙකට appeal කරන්න බෑ. කෙලින්ම jurist කොහෙද යන්න ඕනේ? Court of Appeal. හැබැයි Court of Appeal lies appeal lies against industrial court. It means that instead of going directly to the Court of Appeal, there is one chance for the party, aggrieved party, to ask the minister to refer to another industrial court. Right? Otherwise, no harm, they can directly go to Court of Appeal. But in between, there is another option for them to appeal. With regard to arbitration award, no such preference, directly go to the Court of Appeal.
So these arbitrators in that industrial court will be different from the ones that
Not that way, sometimes those who are, working as arbitrator can be appointed as the, arbitrator in the industrial court as well. This is not separate court, right? We both are compulsory arbitrators, but the general man, the lawyer who has substantial knowledge can, investigate into the matter, the industrial dispute, and can award can be made. But if it is a huge strike in the country, the gravity is more. Very, the situation is serious. So referring to just an arbitrator, dragging it for years and years, it should not be allowed. So that is why the arbitrator, but some higher authority, not authority, the industrial court, the unities industrial court is there. So if matter is industrial dispute is very grave, and then this matter, instead of referring to one arbitrator, refer to the industrial court. Then there may be 3 arbitrators from the industrial court. It depends on the gravity of the problem. Okay? However, remember what you need to understand is there is no appeal procedure for arbitration award. Directly aggrieved party or disagree, if you are, either party disagree, then they can go to Court of Appeal. But if the matter has been referred for industrial court, right, the one party is not satisfied. So then that party has, instead of directly going to Court of Appeal, there is another option for them to appeal. to the minister. Right? If minister refuses it, go to court of appeal. But court of appeal, going for court of appeal is costly. So that is why one more chance.
So now, for finally, arbitrator and it has to be court. So let's say one party is not happy with the vote by the arbitrator, which is a minor.
Okay.
Then when he write to the minister and appoint another arbitrator.
No. No. Only option. The aggrieved party from the award directly go to court of appeal. Minister, we have, right, during my tenure, one trade union, they made make an appeal. They made, submitted an appeal to the minister. I very nice talked to them. This matter has been referred for arbitration, not for industrial court. Therefore, minister has no jurisdiction, right, to refer this matter for another arbitrator or industrial court. So the only option that you have is to go to court of appeal.
So we go to industrial court and other industrial court.
Yes. Well, so it doesn't mean that the aggrieved party from the award granted by the industrial court are prevented to go to court of appeal. They can. But if it is a major matter, a court of appeal settling it takes time. Says right. Large number of people are affected. So that is why instead of dragging this, minister has given another chance, right, to look into the appeal. Okay, right, well. Industrial Dispute Amendment Act number 22 of 2022. Effective date. Employer to furnish a security in respect of an application to the Court of Appeal against an award made by an arbitrator or industrial court. Yanavana, මොකටද කරන්න ඕන? Security. So if some money has been mentioned in the award to be paid by the employer, then employer must deposit that money and go to the higher court. Right. Well. So look at this very carefully. Try to understand yourself. Then after 5-6 minutes later, I will explain. What is dispute resolution mechanism? Industrial court and arbitrator. What about the decision given by the under the settlement? If someone do not agree in the settlement later, so do they have a chance to go to court? Again, the settlement, not settlement. However, if Commissioner General is giving kind of an order, right? Or decision, then against that decision they can go to, but 12 is settled, not a decision of the commission. Okay, well, this is the dispute resolution mechanism, industrial court and arbitrator. Dispute arises, matter will be referred to arbitrator or arbitrator of or in the O, not of O, industrial court. Industrial court එකේ arbitrators තමයි. අර ප්‍රශ්නේ ලොකු ප්‍රශ්නයක් හින්දා තනි මිනිහෙකුට දාන වෙනුවට වෙනම entity එකක් හදලා තියෙනවා ටිකක් වැඩි knowledge එකක් තියෙන මිනිස්සුන්ගේ court එකක. හරි? Right. Award is granted. Right. Against this award, either party can go to Court of Appeal directly. If employer goes to Court of Appeal, if money to be paid by the employer has been mentioned in the award, that amount of money should be deposited with the Commissioner General as security. Otherwise, you can't go to, the employer cannot go to photocopy until the security is deposited. Employee directly, like, because there is no payment to be owed, money to be deposited by the worker. If this happens, the security deposit, it relates to the employer. Say, trade union do not agree with the award of the code of practice or industrial code to arbitration. In the trade union, there is no money to be deposited. This money, don't misunderstand. Security means if award has mentioned some amount of money to be paid to the aggrieved party award, say, ආමුදාට ගෙවන්න කියලා කියන්නේ නැහැ නේ. ආමුද ගෙවන්න දෙන්නේ සේවකයා. මේ ඩිස්පියුට් එකේ හින්දා මොකක් හරි මුදලක් තීරණය වෙනවා. පහුගිය වැටුප් හරි මොනවා හරි නැත්නම් ටර්මිනේෂන් එකක් නම් ටර්මිනල් බෙනිෆිට් හරි මෙච්චරක් ගෙවන්න ඕන. That is the award. So, if employer against that decision, the employer can go to Court of Appeal depositing the amount mentioned in the award. So, when a security නෙවෙයි කියන්නේ. award එක ඇතුලේ තියෙනවානේ යම් කිසි මුදලක් හරි පඩියක් හරි මොනවා හරි මේවා ගෙවිය යුතුයි. ඒ ආර්බිට්‍රේට් award එකක් දෙන්න මොකද? dispute එකකනේ. dispute එක වෙන්න පුළුවන් මොකද? termination එකක් වෙන්න පුළුවන්. strike එකක් වෙන්න පුළුවන්. unemployment කියන්නේ strike period එක කියන්නේ drop out කිව්වම unemployment රජාව දෙන්නේ නැහැ එහෙම දෙන්නේ නැහැ. හරිද? ඒකට money කියන්නේ ටික වැටුප් ගෙවන්න ඕනද? ඒක තියනවනේ award එක. award means what? There are some, conditions to be fulfilled. ඒක ඇතුලේ මුදලක් සලහන් වෙනවා. amount එකක්. ඒ amount එක එහෙම පිටින්ම තැම්පත් කරන්න ඕන Commissioner General ගාව before go to Court of Appeal. Otherwise, if money has not been deposited, Court of Appeal will not accept that. Okay, is it clear? Right. So then, again, they can go to Supreme Court, right? And here on the other side, they neither, they do not. The employer does not does not adhere to the award, and no application made to the Court of Appeal. Then, Labor Department, at least within 1 year, should go to the magistrate court in order to implement the award. Why? The employer has not made an application, to the Court of Appeal against the decision. He neither accept nor against. So therefore, in order to implement the award, the Labor Department should go to the magistrate court. Okay, right? Now Labor Department goes to magistrate court. Magistrate court gives an order in favor of the arbitrator. I mean, affirm the arbitration award in case. Then the employee has a still chance to go to Court of Appeal. Here Court of Appeal, right? Here Court of Appeal, right? This not some part is missing. Court of Appeal. Then the magistrate, the Labor Department goes to magistrate court. Why? The employer is mainly not against workers but against employer, right? Employer has not adhered to the award, not against, he has not made an application to the Court of Appeal. So therefore, commissioner has to enforce this. In order to enforce goes to the magistrate court. Magistrate court affirms the award. Example. Then still the employer has chance to go to high court against the decision of the magistrate.
Now, is there a possibility for magistrate court to go against the court that is being,
Yes, possible. Possible.
but actually that's possible.
It may happen. Award, say for example, award has been granted in favor of trade union or worker. Right? So therefore, employer does not adhere, and also not going to the court of appeal as well. So then what is the duty of the, how do we enforce this?
Yeah, so that, what my question is, the employee would go to, sorry, the commissioner would go to magistrate court to enforce the.
Yes.
So there can't be any possibility that MC will give some judgment against the word set by the commission.
Possibility. There is possibility. Why? The magistrate looking at all the aspect and say award is wrong. Say, why not? Award, say for example, the strike, right? Strike. During the award, one award is for 1 month strike. Basic salary for the workers for the period of strikes has to be paid. That is 1 award. Okay. So employer and employment is continued, but not made what you call this the back wages. Right? For the strike period is not paid. Not paid in the sense employer silent. He is not paying it. He's silent. Never paid. And never go to court of appeal against the award. Then in order to implement this, the commissioner goes to magistrate. The magistrate court may say that there is no need of payment for the strike period. May.
This is the purpose of going directly to court of appeal.
Let's see. Court of appeal.
Then in that case, why should the employer go to court of appeal? Can't the employer go to
Employer has no right to go to MC. You have to understand the legal procedure. Employer has no right to go to MC.
the commissioner can
Only the commissioner can. Commissioner is going to impose this. Impose this because for the strike period, employee is not paid. That is, one aspect of the award, right? One segment of the award. Okay. All other employer agree, but that part is not agreeing. It's not going to court of appeal. So in order to implement that part, the the commissioner should go to the magistrate court. 90% the award may be affirmed, right? But there may be the different opinion from the magistrate court. If different opinion, if magistrate court says no, there is no need of back pay, then be the case may
so then the employee can go to my court.
the worker, yes, trade union, let me come. Then against that decision, right, employee or trade union can go to high court. In case the magistrate court affirm the award, then the employer also has right to go to high court by depositing the money as security. and again Court of Appeal and the Supreme.
Let's say, body granted by the body recommended by the arbitrator, and then if employee doesn't agree, so he files.
Employee,
Employer doesn't agree, and he files the case at Court of Appeal. Okay.
Hmm.
Then again, Court of Appeal affirms that, and employer so goes to Supreme. Then Supreme Court also affirms to enforce it. Goes to
again Commissioner General has to go to magistrate.
magistrate. Then let's say he doesn't do that, employer. Then you don't have to again go through that.
No.
This is there.
It comes like this final
So
here.
it doesn't again come.
No, because Supreme Court,
Yeah.
you can't go.
Yeah.
So
it's
to
a
go
final thing.
to, that's the final thing. Because you have to understand the hierarchy of the court. Right. The magistrate and district court, provincial high court, Court of Appeal, and Supreme Court. You can't go to, if you want to go for a superior court is, that decision is the highest. Right. If you want to change it, right, again you can appeal to the Court of Supreme Court.
Fine.
Or by bench, by bench.
Okay, so three bench, interviews, so went to five bench. Supreme Court, and again.
That is the point.
You got to-
No can't go, nothing to do.
So then, if he doesn't pay, what happens?
Doesn't pay means they will be, because here, right, when once it is, when the Commissioner General goes to implement the Supreme Court decision at the magistrate, he will be in prison. The person employer will be there in prison.
But subject to maximum 12 months.
Subject to maximum 12. Right. Is it clear for the participant from online? Right. So labor tribunals. A workman or a trade union on behalf of a member may make an application in writing to a labor tribunal for relief or redress in respect of any of the following matters. The termination of his services by his employer within 6 months of such termination. B. The question whether any gratuity or other benefits are due to him from his employer on termination of his services and the amount of such gratuity and the nature and extent of any other such benefit. Such other matters relating to the terms of employment or the conditions of labor of a workman as may be prescribed. මේකත් අර සීවකෝ 15ට අඩු තැන්වල තමයි මෙහෙම යන්නේ. right? ගැටිවිටි ඉල්ලලා යන්න පුළුවන්. ඕපිට් කරාම ගැටිවිටි ඒක හරිද කියලා බලන්න යන්න පුළුවන්. But mainly majority the termination. Okay? Labor tribunal jurisdiction. Application to a labor tribunal, section 31B. B1. Section 31B. A workman or a trade union on behalf of a workman who is a member of that trade union may make an application in writing to a labor tribunal for relief or redress in respect of any of the following. I'm repeating it. The termination of his service by his employer, the question whether the gratuity or other benefits are due to him from his employer. I already explained this, but specifically mentioned, highlighted in any industry employing less than 15 workmen or any date during the period of 12 months preceding the termination of, again, say, terminate which same thing in a different way. Application to a labor tribunal, section 31B. C. The question whether the forfeiture of gratuity in terms of payment of gratuity act number 12 of again forfeit කරාම රඳව ගන්න එකට එරෙහිව යන්න පුළුවන්. such other matters relating to the terms of employment or the conditions of labor of a workman as may be prescribed. So these are the matters that can be referred for LT, Labor Tribunal. Section 31B4. The Labor Tribunal has not bound by the terms and conditions of the contract of employment. What about collective? There are some provisions in the collective agreement. The collective agreement imposed. Right? There are some clauses in the collective agreement. Here says section 31B. Before, the Labor Tribunal is not bound by the terms and conditions of the contract of employment. Labor Tribunal. What about collective agreement? Any conditions or terms and conditions, any condition, terms or conditions stipulated in the collective agreement imposed cannot be altered or cannot be ignored. Labor Tribunal, because it's a legal document, Labor Tribunal does not have any right to change or give any order contradictory to the terms and conditions in the collective agreement. Contract of employment එකේ order එහෙම පුළුවන්. Contract of employment එක ආමුදයි දේව කියලා තමයි එක. Collective agreement එක both trade union අස්සන් කරනවා. ඒකේ තියෙන ඒවාට ඇඟිලි ගහන්න කාටද බැරි? LT එකට බෑ. But the LT is not bound by the terms and conditions of the contract of employment, not collective. Okay? මේවා concrete. Hey, concrete කියන්නේ? Case තියෙනවා, decisions තියෙනවා, high court decision සැලකිලි ප්‍රමාණය. නියලු සායෝ. එහෙම ගිහිල්ලා තියෙනවා. LT collective agreement වල තිබිච්ච එකඟ වෙච්ච ඒවාට බලපෑම ටික වෙනස් කරලා ඕඩර් දීලා තියෙනවා. ඕඩර් දීලා තියෙනවා. ඒවට එරෙහිව දේවායෝනික කවුරු හරි නියලු සායෝට ගිහිල්ලා කියලා තියෙනවා. No jurisdiction. LT has no jurisdiction enter into terms and conditions of the collective agreement. But yes, with regard to terms and conditions of the contract of employment, it can be altered. Okay, by the LT.
The president, the
Big Patlogan Lepa, LT is totally entirely different.
earlier only you said.
Earlier, it's come under arbitrator. LT president can be appointed as an arbitrator. Then his role is arbitrator's role. Here, LT role is different. LT is another mechanism. Okay? Don't mess up. Right. So, the complaint should be made to the Labor Tribunal within 6 months, within the period of 6 months from the date of termination of the service of the worker. Right? මම කිව්වකෝ ආපහු පටලව ගන්න එපා. Termination එකේ යටතේ තිබුණා, sorry. Arbitration යටතේ තිබුණා LT එකට refer. ඒ කියන්නේ LT එකට refer කරනවා නෙමෙයි. LT president කෙනෙකුටත් arbitrator කෙනෙක් හැටියට full perform කරන්න පුළුවන්. ඒ නිසා එයා arbitrator කෙනෙක් හැටියට minister හරි DGL පත් කරන්න පුළුවන්. ඒකට එයාගේ role එක මේ LT එකේ role එක නෙමෙයි. arbitrator ගේ role එක. LT එක කියන්නේ වෙනම jurisdiction එකක්. හරි. මෙතන legal power එක වැඩි. LT කියන්නේ half ඒකට කියන්නේ quasi judicial. arbitrators ලා quasi judicial නෙමෙයි. right? අර්ධ අධිකරණ නෙමෙයි. ඒක settle කරන්න බලන්න. මෙතන දෙන්නේ අතන දෙන්නේ award එකක්. මෙතන දෙන්නේ order එකක්. right? Arbitration එකේදී මොයි arbitrator and industrial court offer or give award, make an award. Labor Tribunal gives an order. Need to understand the difference. Right? Order. Well, relief granted by the LT, reinstatement in service with or without back pages or with part of back pages. පසුවැටුප් සහිතව හෝ සම්පූර්ණ හෝ අර්ධ හෝ, it is up to the LT to determine. Compensation in lieu of reinstatement. නැවත සේවයේ පුනපත් කිරීම වෙනුවට වන්දි නියම කිරීම. Awarding gratuity on a specific application where the employer has less than 15 employees. සේවක 15ට වඩා අඩු ආයතනයක සේවකයන්ට gratuity act එක යටතේ gratuity හිමි නැහැ. හැබැයි මිනිහෙකුට හිතනවා නෑ මට gratuity ඕනේ සේවකේ. right? එයාගේ සේවාව terminate වෙනවා. හරි නැත්තම් resign වෙනවා. නැත්තම් retire වෙනවා. ඒ කරලත් LT එකට application එකක් දාන්න පුළුවන් මට gratuity දුන්නේ නැහැ. ඒක award එක දෙනවද නැද්ද වෙනම දෙයක්. එතෙන්දී බලනවා gratuity ගෙවන්න තරම් whether the employee has sound financial situation, right? Whether how many years this person has worked for the company, what was his contribution, and then just based on just and equitable, the LT decides whether this person has right for gratuity or not. Okay. Order pertaining to the correctness of the forfeiture of gratuity. Gratuity එක forfeit කරාම ඒක හරිද වැරදිද කියලා බලන්න LT එකට යන්න පුළුවන්. We have court cases, right? ML Lanka Private Limited versus CGL writ application 2017 decided on 2017. Telinco General Insurance Limited versus CGL decided on 12th of December 2023. Very recent case. Right? Well, any relief or redress may be granted by a labor tribunal to a workman upon an application made under subsection 1, notwithstanding anything to the contrary in any contract of service between him and his employer. I already explained. In other words, LT can ignore contract and give some relief to the employee, not collective agreement, only contract. The LT shall make all such inquiries into that application, and hear all such evidence as the tribunal may consider necessary, and thereafter make such order as may appear to the tribunal to be just and equitable. Here, order. Arbitrator, award. Industrial court, award. Right. Well, the procedure can be decided by the LT. Unlike other courts that have to follow a very strict procedure, then මේකත් එහෙම තමයි වෙලා තියෙන්නේ. But so, the guideline to follow when making just and equitable award and orders, just and equitable awards කවුද දෙන්නේ? LT and Labor Tribunal and Industrial Court. Order කවුද දෙන්නේ? LT. වචනවල වෙනස තේරුම් ගන්න. Award and order. Order එකක් දුන්නා ඕක ක්‍රියාත්මක කරන්න මොකද වෙන්න ඕනේ? ඔය LT එකේ order එකක් දුන්නොත් ඒක ක්‍රියාත්මක කරේ නැත්නම් මොකද කරන්න ඕනේ? Again, Labour Commissioner General තියන්න වෙන කොහෙටද? ආපහු මේ කොහෙටද? Provincial High Court. LT එකට දෙන එක ඊට ඉහළ උසාවියකින් එපා ඒක මේව කරන්න. Right. So, just and equitable guidelines. The law of the land should be followed. රටේ නීතිය පිළිපදින්න ඕනේ. The tribunals and arbitrators should act judicially by following the principles of natural justice. Judicial procedure එක තමයි. But follow කරන්න ඕනේ මොකද්ද? of natural justice. Magistrate court එකේ natural justice follow කරන්න කියලා නීතියක් තියෙනවද? නැහැ. Magistrate court, high court, court of appeal ඒවයි මොකද? Prove beyond the reasonable doubt. ඒවයි prove කරන්න ඕන මොකද්ද? Beyond the reasonable doubt. අපරාධ නඩුවල එහෙමනේ තියෙන්නේ. ඒකට just and equity principle එක follow කරන්න ඕන කවුද? Arbitrators, industrial court and LT. Those are quasi judicial. අර්ධ අධිකරණ ස්වරූපය. අධිකරණ ආධාර. So every material, so following the natural principle of natural, what do you mean by principle of natural justice? There are two elements when we talk about principles of natural justice. So how principles of natural justice. Arbitrator and industrial court, we are not talking about what you call natural justice, but we just and equitable. Here, not only just and equitable should follow the natural justice process. When you say natural justice, there are two elements. What are those two elements? When we say natural justice, what does it mean? There are two elements. One is French වචනයක් තියෙනවා audi altrum partem. ඒ කියන්නේ listen to both parties. At least there should be two parties involved to the industrial dispute. At least workers and the employer. So listen to both parties. One element. Another element, no one here his own case. තමාගේ නඩුවේ තමාම විනිශ්චයකාරයෙකු නොවිය යුතුය. No one here should hear his or her own case. So this is the natural justice, right? And every material question involved must be considered. හැම දෙයක්ම සලකලා බලන්න ඕනේ. Orders or awards should contain reason, therefore, ඒවට orders දෙනකොට ඇයි reason කියන්න ඕනේ. The tribunals and arbitrators must not act arbitrarily. Right? And we have court decisions, cases, right? I have mentioned it, right? We have this guideline have been prepared based on these judgment. The judgment වල තමයි මේ කියන්නේ.
Sorry.
Yes.
Lines to
Natural justice should apply at the LT. Not only natural justice, they have to follow just and equitable principle as well. But natural justice, we are not touching upon discussing natural justice under the arbitrator and industrial. Arbitrator and arbitration and industrial court should follow. Should grant award based on just and equity principle. But LT, just and equity principle as well as should follow the natural justice. Subhavokti nitiya follow karando. Right. So some other case as well. There are cases. Millers Limited versus Ceylon Mercantile Industries and General Workers Union. Long back ago, but still valid. In this case, Justice Bandaranaike observed that an award is just and equitable only if it takes into consideration the interest of all the parties. Again, just and equity principle. එක සැලකුවා කියන්නේ හැම කෙනෙකුගේම right all again interesting. සැලකිල්ලට ගන්න ඕනේ. ඒ කියන්නේ here the both parties, right? ඒකත් වෙනවා ඇත. And Associated Cables Limited versus Palutaragi, right? it was held that although the labor tribunal was required to make a just and equitable order, it must not only be just and equitable, but the procedure adopted to that end must be legal, and every judicial body exercising judicial powers must so arrive at an order only on legal evidence. එන්නේ නීතිමය සාක්ෂි මත මේ කියන්නේ just and equity විතරක් නෙමෙයි. මේ LT එකට එනකොට අර legal procedure එක judicial procedure එක follow කරන්න කියලා කියනවා. හරි. ඒ කියන්නේ order එකක් දෙනකොට මේ cases තියෙන්නේ, you can read it later, right? කවුද මේ සදා T Company Limited versus Tuari Jayasuriya. Justice Jayasuriya stated that although the power conferred with by that section is a wide one, there are limitations to the exercise of it which are implicit in the wordings of the section. That is to say, the power is to be exercised in accordance with the justice and equity and not arbitrarily. ඒ කියන්නේ මේ නඩු තීන්දුව වලින් කියන්නේ මොකද්ද? LT president ලා කටයුතු කළ යුතු ආකාරය. right? arbitrarily කටයුතු කරන්න බෑ. හරි, just and equity principle follow කරන්න මේ හැම එකෙන්ම කියන්නේ. right? arbitrators ලා ගැනත් මෙතන කියනවා. So you read it already, one is enough to understand. There are again, some other like relief that can be awarded by the LT. මොනවාද relief LT? මම මේක කිව්වද මන් දන්නේ. කලින් කිව්ව නේද මේ? කලින් ඒකේ තිබ්බද බලන්න repeat වෙලාද මගේ. Relief that can be awarded by the LT. If the termination is held to be justified, the labor tribunal will dismiss the application. Dismiss the application. What does it mean? If the termination is held to be justified. Again, සේවා යෝජකයා විසින් කරන ලද සේවයෙන් පහ කිරීම, සේවයෙන් නිරපා හැරීම justifiable නම් මොකද කරන්නේ? Dismiss the case as application. If the termination is found to be unjustified, the labor tribunal can A. reinstate the employee with or without back wages for the period of unemployment, and or B. make an award for compensation for loss of employment. In the case of domestic servant, personal secretary, personal clerk, personal attendant, or kaufer කියන්නේ රියදුරා, ගෙවල් වල රියදුරා, like kaufer. If the termination is found to be unjustified, the employer must be given an alternative to reinstatement in terms of compensation. මේගොල්ල මේ LT Act එක Industrial Dispute Act එක විතරයි domestic workers ලා ඔය කවුපලා ඔය අය සම්බන්ධයෙන් ඒ කියන්නේ dispute එකක් ආවොත් කටයුතු කරන්න තියෙන එකම act එක ඔච්චරයි. වෙන මොකුත් නැහැ. අනිත් act වලින් මේගොල්ලෝ cover වෙන්නේ නැහැ. ආවරණය වෙන්නේ නැහැ. Only these type of workers are covered only by the Industrial Dispute Act. Both employer and employee can appeal against the decision of the labor tribunal to the provincial high court on a question of law. Right? Both provincial high court. If both employer and employee can go to court of appeal against what? Against award of an arbitrator and a word of industrial court. Industrial court, there is in between more one aspect or one chance to appeal. Well, an appeal against LT order, the employer can appeal to the provisions of High Court, 30 days, within 30 days from the date of the order. Order එක දීලා මේක මර මාසෙ කියලා කිව්වේ මම මේක within 1 month. It is mandatory depositing the required amount of money under section 31D(4) if the employer appeals. Vimalasiri Pereira versus Lakmali Enterprises, 2003. Being an employer fails to comply with any order made in respect of him by a labor tribunal shall be guilty of an offence under this act. Again, comply with an offence. Any modification or alteration made to the order is null and void. Any modification or alteration against the order can go to higher court. But no, either employer or worker can go to higher court in order to ask him to alter or modify the award. Right. Modification, alteration are not possible. Offences related to settlement, awards and orders. Look at this very carefully. Offences related to settlements, award and orders. Settlement by whom? Settlement where? Settlement comes under what? Settlement comes under conciliation. I mean, as a result of conciliation. Settlement is the result of conciliation. Okay? What? You know, I have repeatedly told you. Labor Department, mainly what they do with regard to industrial dispute is a conciliation. Conciliation is successful, then sign memorandum of settlement. What do we call 12-1 agreement? That is settlement. Settlement at the Labor Department level. Award, arbitration and industrial court. Order, LT. I'm repeating, settlement at the departmental level, Labor Department level. Awards are granted by arbitrators and industrial court. Orders are given by the labor tribunal. Okay? Failure to comply with orders awards or order. Keeping in employment any workman on less favorable terms than those specified in such settlement, award or order. කියන්නේ employment එකට අර award එකේ settlement එකේ order එකේ තියෙනවට වඩා අඩු දේවල් දෙන්න commencing a lockout මේවට offense එහෙම වුණොත් මොනවද වෙන්නේ offenses commencing a lockout or strike with a view to procuring the alteration of the terms of a settlement award or order ඒව වෙනස් කරන්න කියලා මොනවා කරන්නද බැරි lockout හරි strike හරි කරන්න බෑ ඒක offense එකක් වරද terminating the service of or reducing to a lower grade or class or otherwise punishing the workman without good cause for the reason that he has become entitled to the benefits of any settlement award or order. Order එකකින් දෙනවා settlement එකකින් දෙනවා එයාට entitled මේවා right හරි higher position එකක් හරි මොකක් හරි හැබැයි ඒවා කඩලා වැඩ කෙරුවොත් ඒක offense එකක්. Commencing, continuing or participation in order to or doing any act in furtherance of or right inciting a lockout or strike in any industry after an industrial dispute in that industry has been referred for settlement to an award in respect of such dispute has been made. ඒ කියන්නේ කවුරුරටත් මැටර් එකක් රිපෝට් කරාම ආබිට්‍රේටර් ස්ට්‍රයික් කරන්න බෑ ලොකවුට් කරන්න බෑ ඒව කරන්න බෑ ඒව කරාම මේක මොකද්ද punishable offense. So these are the offenses. Well, any question? Right. Enforcement of awards and orders. If the employer fails to comply with the order, the commissioner may file a case against the magistrate against the employer under section 136 of the criminal procedure. Criminal procedure. The case will be tried summarily. Again, summarily. ලඝු නඩු විභාගයක්. හරි සිංහලෙන් කියන්නේ ඒක ලඝු නඩු. Sorry. Immediately in the sense, when it's like this, when Commissioner General file, submit a certificate, it is accepted by the magistrate. It is accepted. Right? Those are not, like charge and complaint procedure. We just follow certificate procedure. Award එක මෙච්චරයි මේක කරේ නැහැ කියලා දුන්න ගමන් ඒක accept. ඒකලා මේක අරන් යනවා. ඒක තමයි summary කියන මොනවාද ඒකට කියන්නේ summarily trial. එහෙම නැත්නම් tried summarily. The burden of proof lies on the employer. වගකීම ඔප්පු කිරීමේ භාරය කාටද දෙන්නේ? සේවා යෝජක. The employer shall be liable on conviction after summary trial before magistrate fine not exceeding 5,000 rupees or to imprisonment of either description for a term or not exceeding 12 months or both such fine and imprisonment. So we have already, previously we have identified this. Any questions so far from the audience? I mean, participants from online? What about you? Is okay? Because we are coming to an end, right? We have a lot of time to discuss. So Industrial Dispute Amendment Act, again I'm highlighting it. Number 22 of 2022. Effective date, so employer to furnish the security in respect of application to the High Court dissatisfied with an order of a magistrate court, OLT, failure to comply with an award of arbitrator, industrial court, and orders of a labor tribunal. Right? මෙහෙට යනකොටත් මොකද කරන්නේ? Security deposit කරන්න ඕනේ. Problems with, current LT. What are the problems with current LT? The entire case may take about 3 to 4 years, depending on witnesses, complexity, administrative difficulties, etc. Another difficulty is the order made by the LT is then difficult to carry out, especially if employee is given the job again. Right. There are two appeals after the LT gives its decision. Firstly, to the Provincial High Court and thereafter to the Supreme Court. The entire process may take a further 3 to 5 years after LT.
So, Court of Appeal is not in between.
I mean, explained to you previously in my slide, right? The employer, sorry, the employer has, right? So let's see. The employer is not satisfied with the LT order, right? The only option that the employer has, directly go to Court of Appeal. Directly, sorry, LT, sorry, made a mistake. Remember, in order, with regard to orders from the LT, against the LT order, only option that the employer has to go to Provincial High Court, not the Court of Appeal. Court of Appeal, the employer has right to directly go to Court of Appeal against the decision of the Commissioner General, against the award made by the arbitrator and the industrial.
Yeah, that is directly. But
No, not directly. I mean, that is the procedure.
But in between the Provincial High Court the Supreme Court is,
No, we need to understand this. Let me go back to. Forget it. Arbitrate the award or industrial court. Award is granted. Award is granted. Then direct provision. There is no indirect. Direct provision. Go to against the award. Go to court of appeal by way of writ of writ application. Okay. You are referring here high court somewhere. You are not understand that. This employer does not go to court of appeal. Does not adhere to the award as well. Is that it? Then, in order to implement this, at least within 1 year from the date of award, the Labour Department Commissioner General should go to the magistrate court in order to what? Implement the award. Like magistrate court affirm the decision of the award. Then only employer has chance to go to high court against the magistrate decision. Not the against the award, he can't go to high court. He can't go to court of appeal. Directly, sorry, here court of appeal, yes, right? Writ application to the court of appeal. If not, he has to wait until the magistrate award is the decision is granted.
that is clear.
That is clear.
My question is not that. Question is now, is the arbitrator or the IC?
Yeah.
Now, I'm saying it in NT.
Hmm.
Now, then the provincial high court and then to Supreme
Yes. Because
Court.
No.
So between high court and.
no,
Supreme
no,
Court,
no.
there
Let
is
me
a-
explain. Right. Let me explain. That is the court proceeding in Thailand, right? LT, sorry, provincial high court acts as court of appeal. It has two jurisdictions. To act as high court, to act as provincial high court, and I mean court of appeal. Has two jurisdictions. Provincial high court. So LT against LT decision directly owing. That is the only way. So go to provincial high court and then against the decision of the provincial high court directly go to court of appeal. Sorry, Supreme Court. So provincial high court has power, right? Power as much as the court of appeal. මේක යන්නේ මතක තියාගන්න. ඕඩර් එකකට එරෙහිව යන්නේ අපීල්. ඒකයි කේස්. ඕඩර් එකක් නේ LT එකේ දෙන්නේ. ඕඩර් එකට එරෙහිව රිට් යන්න බෑ. ඕඩර් එකට එරෙහිව යන්නේ මොකද්ද? අපීල් එක. අපීල් යන්න ඕනේ කොහෙටද? කෝඩ් ඔෆ් අපීල් නෙමෙයි. ඒක කෝඩ් ඔෆ් අපීල් කියලා කියනවා තමයි. ඒව කේස් වලදී. කෝඩ් ඔෆ් අවෝඩ් වලට settlement ඒවට තමයි court of appeal එක. හරිද? LT එකේ දෙන්නේ order එක. order එකට against යන්න ඕන කොහෙටද? decision එක යන්නේ order එකක්. order එක එරෙහිව යන්න තියෙන්නේ appeal එක. appeal එක යන්න තියෙන්නේ provincial high court. ඒක jurisdiction එකේ තියෙන විදිය. We can't argue on that. That is what is there in law. Remember, against LT, either employer or worker should go to against the LT decision should go to provincial high court, not to the court of appeal. But when it comes to employment law, employer can go to should go to court of appeal against the decision of the Commissioner General and award granted to made by an arbitrator and the industrial. Is it clear? Don't misunderstand. We can't ask why. This, there you go, I don't know. That is the procedure. Well, it was equal to you. එහෙම තමයි ප්‍රශ්න කරලා ඉගෙන ගන්න ඕනේ. සමහර වෙලාවට මම කියන විදිය ටිකක් තෝරන එක හරිය නැද්ද, but this is the way I teach. Don't take it personal. Sometimes I shout. That is the way I teach. හැබැයි මගේ හිතේ මුකුත් තරහක් එහෙම නැහැ කාටත් එක්ක. Right. Yeah, 49, right. So thank you for your active participation. Now, time for questions. There may be many questions. Okay, praising and many clarifications. Oh, doubt and nothing. Even after equaling one of the නැති තව ප්‍රශ්නයක් නෑ. අපි time එක නෙමෙයි වැදගත් වෙන්නේ whether you learn or not. Any question? When the slide goes unknown again, I will go for that. Any question from the participant online? Yes.
Just to clear it,
Oh.
you said the price to entity apart from the just an equitable. No?
Oh.
Now, in one slide it says the tribunal and the arbitrator should act judicially by following the principles of natural justice.
ඔය නඩු තීන්දුව කියන කියන්නේ
The arbitrators
මෙහෙමයි. ආර්බිට්‍රේටර්ස්ලා ඕන කෙනෙක් natural justice follow කරන්න ඕනේ. හැබැයි ආර්බිට්‍රේටර්ගේ and industrial court එක විශේෂයෙන් සැලකිලිමත් වෙන්න ඕනේ. natural justice කියන්නේ ඒකේ කොහොමද දෙපාර්ශවයට අහුම් ගන්න එපා. ඒක කියනවානේ arbitrarily act කරන්න බෑ කියලා. award එක දෙන එකනේ. They should follow the natural justice. Everyone should follow the natural justice. Right? Once they are awarding, award should be based on just and equity principle. Okay? Don't misunderstand. If I say, the arbitrator should not follow or have no need of following natural justice, no. Everyone, when it comes to employment law, if it is not a violation of law, when it comes to, industrial dispute, natural justice is important. Disputes, there are two parties. So therefore, listen to both parties. Natural justice means listen to both parties and එක පැත්තකට බර වෙන්න ඕනේ නැහැ. No one hear his own case. Again, neutral වෙන්න ඕනේ. So everyone should follow natural justice when it comes to industrial dispute. But arbitrators should give the award based on just and equity principle. එකයි කියන්නේ එකක අදහස් කරන්නේ LT එකට ඒවා කොහොම ඒවා follow කරන්න ඕනේ. ඒක emphasize කරන්නේ නැහැ වැඩිය. Arbitrators ලගේ එකේදී natural justice කියන එක they should follow. හැබැයි ඒක specifically අර clause එකකින් කියලා mention කරලා. They should follow it. Definitely. Any question from online participant? Oh, එක තමයි listen to both parties. Listen to both parties. Audi Ultram Partner. Listen to both parties. Two elements. Number two, no one should hear අහන්න හොඳ නැහැ. නඩු අහනවා කියන්නේ. Hear his or his her own case. තමාගේ නඩුවේ තමාම විනිශ්චයකාරයෙකු නොවිය යුතුය. No one hear his he or her own case. own තමාගේම එක තමාම අහන්න හොඳ නැහැ කියලා කියන්නේ. Okay? Natural justice has two components, right? If you go check with the internet, right, these two words will come definitely. What else? We have another 1.5 hours. But normally it's up to 3 hours, so 3 o'clock. Too much. Never. Any question from participant? Sarasi, is it clear?
Clear, sir.
Thank you. And Chandras, oh, Chandrasena. Salika, anything from your side? Is it clear or
Yes, sir.
okay. Ramesh? Okay. Mihiri? Mihiri da Mihiri wala desane.
Yes, sir, it's clear. Sorry, I
Yes,
was
sir.
Sorry, Mihiri.
driving.
Okay, right. So then if you don't have any question, why we should waste time? If you have understood very clearly, I feel, this was very attractive. Attractive in this constructive, right? You raised many questions. I think you will learn a lot, right, from this one, right? What I said is very concrete, based on the judgment and some point based on judgment. And this is the very Sri Lanka has very clear provisions in relation to settlement of industrial dispute with regard to the private sector dispute, in relation to private sector industrial dispute, not the government sector. So conciliation, arbitration, and LT, three main options. We have conciliation first, and then if failed, arbitration. With regard to termination, the labor tribunal. Right? Well, so they would be yes.
Next week, you think?
Which one?
Next week.
Which
is
means what is
only
that?
for conciliation.
Sorry?
Next week class is only for conciliation.
Conciliation?
That was what is the
The 2 months, I don't know, right? If I will be asked to do the conciliations and mechanism for settlement, forms of worker participation, forms of worker participation means either one trade union or there is nothing to individually. I don't think who has prepared it. And the collective bargaining, skills for negotiation, that one is separate one. Arbitration, industrial courts, legal tribunal, appeal, all these. But I don't know who is doing this. Agreement, collective agreement, offenses. There are many things to be covered, right? For example, industrial dispute in the context of present, from the global perspective. There are many things. I don't know. So mechanisms for settlement, 4-6 hours. Mechanism for settlement, this is the mechanism for settlement. Workers are participating, employers are participating. Not please, is that ambiguous, right? Not unambiguous. And again, look at all these collective bargaining skills, need for negotiation skills, listening skills. Make an uncommand collective bargaining. Collective bargaining, whenever there's an answer, very nice. මෙතන තියෙන්නේ summary. මෙතන තියෙන්නේ summary.
pretty much covered.
Already covered. හැබැයි ඉතින් අර මොනවද කියන්නේ අදින්න පුළුවන් cover එක වගේ. එහෙම අදින්න දැන් මගේ ළඟ conciliation වලට වෙනවා 3-hour presentation එකක් තියෙනවා. I can be dragged it for 6 hours. Right? සාමාන්‍යයෙන් අපි කරන්නේ මේ එක separate කරනවා නම් then mechanisms for settlement Forms of worker participation, forms of worker participation, what does it mean? Workers are participating by, way of, the collectively or individually in industrial dispute. ඒකේදී එහෙම නැත්නම් මේ කියන්නේ trade union කියන්නේ I don't know. But I have focused, this is the entire mechanism for industrial, settlement, right? Dispute settle. I don't know something else is this one. But because settlement of industry, that's what I got the message, right? What do we settle? Other settlement, do you need other types of settlement? Are we supposed to? This is diploma in legal law and industrial relations. When it comes to industrial relations, settlement means dispute settlement. Is there anything else? Dispute එකක් නේ සේවා නියුක්තියට අදාළ ඕනම එකක් මොකද්ද? Dispute. Industrial dispute එකක්. Dispute එක transfer කිරීමත් dispute එකක්, උසස් වීම නොදීමත් dispute එකක්. Conciliation. But anyway, I will be asked to do this. We can discuss many things. Public cases. Public case. Case. Focusing on cases. And then I will bring some certain when it comes to the conciliation advantages of conciliation method. Yes, I do have. I will bring some other cases. Case study will be discussed like this. And the collective bargaining as well. Arbitration, industrial court, legal tribunal, agreement, collective agreement, offences. I'm collective bargaining, collective agreement. Collective bargaining කියන්නේ මොකක්ද? දෙගොල්ල දෙපැත්තට වෙලා මෙහෙමයි මට පුළුවන් ඔකට වරුවක් විතර දාන්න මේ ඔන්ලයින් ඉන්න අයට ප්‍රශ්න තියෙනවා. නැත්නම් දෙගොල්ල දෙයා හාම්පුතුම ඕගොල්ලෝ මේගොල්ලෝ ට්‍රේඩ් යුනියන් කියලා collective bargaining table එක හදාගෙන right agenda එකක් හදාගෙන agenda එක මත negotiate. That is one collective bargaining. අන්තිමේදී එකද වෙලා සමහරවිට එකක වෙනවා ඒක ලියවිල්ලක් හැටියටපත් කරලා මොකද කරන්නේ? ඕක ඇග්‍රී වෙනවා දෙගොල්ලෝ අස්සන් කරාම ඒක collective agreement. මේක පැය 6ක් පොඩම කරන්න මම දන්නවා. දැන් මේ මොකද්ද මේ මොඩියුල් එක මොකක්ද? මොඩියුල් 3 කියන්නේ industry settlement of
Industry. That
ඔව් ඉතින් උට මොඩියුල් කීයක් තියෙනවද කොහොමද? හරි මේ තුන්වෙනි මොඩියුල් එකද? දැන් මේකට දාන්න තිබ්බා. මෙහෙම නොවේ නා. කියන්නේ මේකට තව ටිකක් දාන්න තිබුණා. මේක කළා industry relation කියන්නේ මොකක්ද කියලා කරා. ටොපික් එකක් තිබ්බා. ඒක එන්න ඕනේ මේකට දෙන්නේ නෑ ඒක ඉස්සරහට තියෙනවා. බලන්න
emerging issues in industrial relations.
module here.
Module 3.
මේක තියෙනවා. ඒක දැන් මේ ඔක්කොම රිපීට් කරලා යනවානේ. Right. Terms and conditions of employment body. Social security.
Done.
Right. Industry relation, trade union and social dialogue. Right. Settlement of industrial dispute. Industry relations, trade unions and social dialogue කළාද? දැන් මේ බලන්නකො මෙතනම තියෙන මොනවද? මේ මොඩියුල් 3 එකනේ. හරිද? මොඩියුල් 3 එකේ මොනවද තියෙන්නේ? මොඩියුල් 3 එකේ තියෙන්නේ P1 P2 අනේ P1 එක නෙමෙයි මේ ටිකනේ තියෙන්න ඕනේ. Terms and conditions of employment.
ඒක 1 module 1.
Module 1. What modules are there?
Sorry. Diploma courses, modules, post modules.
ඔයාට තමයි module එක.
මේ 8 මොඩියුල් අත terms and conditions of employment හරි social security හරි ඊට පස්සේ industry relations trade unions and social dialogue
ඒ වෙනුවට මේක
හතරවෙනි එක දැන් කරා.
හතරවෙනි එක තුන කරලා දාන්න.
ඔය දැන් කරන්නේ හතරවෙනි එක සර්.
it is settlement of industrial disputes
ඒත් ඔය ඔක තියෙන හතරනේ එක.
ඔව්
දැන් තමයි සර් පොඩ්ඩක් කරන්නේ.
දැන් මෙහෙමයි settlement of industrial disputes කියන එකම මෙච්චර කරන්න දේවල් නම් නැහැ right එතකොට මේකේ කෝ social industrial terms and settlement of termination of emergency industrial relations occupational safety and health legal system දැන් එහෙමනම් මේකට දාන දුන්න settlement of industrial dispute නේ එතකොට මේකට තමයි ඇඩ් කරන්න තිබුණේ ඇත්තටම what do we mean by industrial relations right and industrial dispute can again in general
ඒක හයවෙනි එක.
එහෙම හයවෙනි එක.
emerging issues in industrial relations I don't understand මේක කරන්න anyway whatever this is important for human resource management you learn something it is forget about the topic but this is relevant for your day-to-day job day-to-day work so that is more important than the topic
ඒක අපි හිතමු කේස් පඩි.
so case studies करो मतलब मैं what are they doing मतलब conciliation කවුද ආයෙ වෙන කරන්නේ කවුද ඔව් කලින් කරනවා මම කියන්නයි කියනනම් මේගොල්ලන්ට මට දාන්න කියලා මේ වුණත් මට ලේසි so I have prepared conciliation separately here everything you know I have covered anyway right but mechanism for settlement forms of worker participation I will try to do something right in case you know the next lectures will be offered for me right එතකොට අර මේකේ තව වෙන වෙන forms of worker participation at least in general ඒක මොනවද කියලා මම දන්නවා දැන් worker participation එකේදී අපි පිළිගන්නේ උද්‍ය සමිතිය එහෙම නැත්නම් group of workers ලා සියලු එක මේකේ trade union කියන්නත් බෑනේ මේ trade union මොඩලයක් තියෙනව නේද වෙනව industrial relations trade union social dialogue social dialogue එක කොහොම නමුත් මේ ටිකටම agreement collective agreement offenses ඒවල් නැහැ අරුණා ඔප කරා නැහැ දැන් මේව මෙහෙමයි මේවා සාමාන්‍ය එකක කැලරි පටල කරනකොට දැන් මම මේව අනිත් ඒවා දැනගෙන හිටියේ නෑනේ මේක මම දන්නේ නැහැ අහල් මම දන්නේ නැත්තේ මේකේ කන්සිලියේෂන් වෙනම තියෙනවා කලෙක්ටිව් බාර්ගේනින් වෙනම තියෙනවා මම දන්නේ නැහැ මට ටොපික් එක දෙන්න මොකද්ද right settlement of dispute right settlement mechanism for settlement what settlement of dispute මොකද මම දන්නේ dispute settle කරන්න මම අනිත් ඒවා දන්නේ නැහැ පවුල් වල අවුල් settle කරන්න ඒක දන්නේ පවුල් සාරදේ පවුල් මේ ඒක නෙමෙයි නායක නොස් මම ඉන්නේ මේක අනේ ඔයා දීලා තියෙන්නේ ඒව තමයි mechanism for settlement also for the party mechanism for settlement what industrial dispute right I don't know other thing anyway එහෙමයි මට කියන්න බෑ මේක මට දෙන්න ඔයාලට කියන්න ඉල්ලන්න පුළුවන් එතකොට මම මේකටත් එක්ක හරියන්න තව අනිකුත් කාරණා so I can you know discuss with you conciliation you know benefits what are the benefits we can discuss right and we can discuss the cases as well
කේස් කරනවා බෑ වඩා
okay තමයි කරන්නේ මේවට අදාළ නඩු තියෙනවා.
දැන් මේක උදාහරණයක් දැන් අපි කේස් එකක් කරේ.
ඔව්.
ඒ අපේකම අරගෙන නාදුගේ
ආ.
කියලා ඒ ටික එකතු කරනවා.
මේම කරන්න පුළුවන්. කේස් එක දෙනවා. කේස් එක දීලා මම උත්තරේ දෙන්නේ නැහැ. රයිට් ඔයාලට කියනවා මේක ගැන ඔයාලා දන්න මට්ටමක් තියෙනවනේ. ඒකෙන් මොකද්ද ඔයාලා ඔයාලට පේන දේ. ඊට පස්සේ ජජ්මන්ට් එක ඩිස්කස් කරන්න බෑ. ඒක ජජ්මන්ට් එක දෙනවා. ජජ්මන්ට් එක කී ඒ ඩිසිෂන් එක
කේස් ලෝ.
sorry what I will put into මොනවද මේ කේස් ලෝ නැතුව මොනවද?
නෑ
ඒක තමයි කේස් ලෝ.
ඔව් ස්ක්‍රයින්
ජජ්මන්ට් එක අපිට විවේචනය කරන්න.
නෑ විවිධනේ නෙමෙයි. පදිගේ
අවසානයේ ජජ්මන්ට් එක දෙනවා. First, right? You among yourself, I mean, you can discuss. After discussion, your view can be expressed, and then we will look at what is the judgment, what judgment says. ඒක කරමු. ඉතින් එහෙනම් මේ ටික කියන්න වෙනවා. එහෙනම් මේකම වෙන්න. Right, good. That is good. Otherwise, මේකේ වෙනම දැන් අපිට තියෙනවා මොනවාද ඔන්ලයින් අය ඔයාලට වෙන ප්‍රශ්න නැත්නම් අයින් වෙන්න පුළුවන් ඊළඟ අයිනකද මේක තියෙන කවද කන්සිලියේෂන් මෙහෙමයි අපි තව ඩිප්ලෝමා එකක් තියනවානේ ඉංග්‍රීසි මීඩියම් ඩිප්ලෝමා නෙමෙයි අය ඩිප්ලෝමා නෑ සර්ටිෆිකේට් ඇඩ්වාන්ස් සර්ටිෆිකේට් කියලා එකක් යනවා ඒකට තියෙන්නේ මේවා කඩ මෙහෙම තමයි ඒවයි තියෙන්නේ මේ සෙට් මෙකනිසම් for settlement. එහෙම එකක් නැහැ. හරි. නමුත් කන්සිලියේෂන් තියෙනවා. ID Act එක කියලා වෙනම නැහැ. හරි. කන්සිලියේෂන් තියෙනවා. collective bargaining ID Act එකේ ID Act first part with regard to collective act. ඊළඟ එක conciliation. right? ඊළඟ එක ඇවිල්ලා arbitration. ඊළඟ කොටස ඇවිල්ලා LC. ඊළඟ කොටස ඇවිල්ලා unfair labor practice. අන්තිම කොටස definition. right interpretation
okay unfair impact
නෑ ඒක මේක නෑ part and industrial dispute
ඒක තමයි
ඒක නෑ
අපි කතා කරේ
නෑ unfair labor practice එන්නේ කොයිද නේද එතකොට ඒක industrial dispute act එකේ තමයි තියෙන්නේ unfair labor practice අසාධාරණ සම්පර්ක පිළිවෙල ඒක වෙනම කතා කරන්න ඕන එකක්
තියෙන්න ඕනේ
ඒක මෙහෙම ඒක ලුකුවට කියන්න දෙයක් නැහැ. unfair labor practice කියන්නේ ඒකේ වෙනම කොටසක් තියෙනවා. ඒ කියන්නේ අසාධාරණ විදියට මාරු කිරීම කියන්නේ හතක් තියෙනවා ඒරියා. 7 ඒරියා. ඒවයින් එකක් හරි කෙරුවොත් ආම්පුතා සේවකෙක් ඒවට ඉන්වෝල් වුණා කියලා මාරු කරොත් ටර්මිනේට් කරොත් අසාධාරණ විදියට සැලකුවොත් ඒක තමයි unfair labor practice එකක් කියන්නේ. ඒකට එරෙහිව මැජිස්ට්‍රේට් කෝට් එකට යන්න පුළුවන් කම්ප්ලේන්ට් එකක් ආවොත්. හැබැයි ලංකාවේ කේසස් 12ක් මේ වෙනකොට දාලා තියෙනවා එකක්වත් ප්‍රූව් කරලා නැහැ. ඇයිද? ඇයි ප්‍රූව් කරලා නැහැ? ඒවයි ලොජික් එකක් ඉල්ල කියනවා මම නෙමෙයි මගේ මැනේජර් එක කරලා තියෙන්නේ. අයි එයා මම කියන්නේ නෙමෙයි. මැනේ ඒකෙන් කේස් එක මොකද සමහර වෙලාවට සාක්ෂිකාරුන්ට සල්ලි දීලා උසාවියේදී නෑ එහෙම දෙයක් උනේ නෑ කියලා. ඒ යුනියන් එකට විතරනේ දාන්න පුළුවන්. ඒ කියන්නේ ආම්බුතාට විරුද්ධව සේවා යෝජකයාට විරුද්ධව විතරමයි මොනවද මේ unfair labor practice යන්න පුළුවන්. against a trade union බෑ. අලුත් ලෝකයේ දැම්මා. අයි trade union ගිහිල්ලා මොනවද කරන්නේ? ස්ට්‍රයික් කරන ගමන්ම එක්කෝ සේවා යෝජකයව ගිහිල්ලා මොනවද නිවාස අඩස්සිය තියෙනවා. එහෙම නැත්නම් දීපුල වලට අලාභාරි කරනවා. එතකොට ඒකත් unfair labor practice එකකට දාලා. ආර්ය hina වෙනවා ටිකක්. තෝංග නැතුව උත්තර hina වෙනවා. ඉතින් දැන් මේ බලන්න agreement, collective agreement, open source. collective bargaining මේක කතා කරනවා skills, need for bargaining, negotiation skills, listening skills, communication skills can be. Arbitration, industrial court, even an active and a legal tribunal, right? Appeal procedure, රූප සටහනින් දාලා වෙන්නවා ආයේ මොකද්ද කියන්නේ කියන ඔය කොළ. ඒ කියන්නේ මතක තියාගන්න. graphs, data, statistics talks more than words. එක arrow එකකින් පෙන්වන්න මුළු පිටු 10ක් කියන දේවල් වල එක diagram එකකින් පෙන්වන්න පුළුවන්. ඉතින් ඒක තමයි what we have done. මේක Kelson for settlement. Terms of work. Right. I will ask them to, continue, this whole module by myself. And it is so. Social security का मम नहीं करे ना? ना एक ही कोटा था. when I activity है करा. So मैं बाबा EPF पे करा.
तुमने नहीं करा
දැන් මම කියන්නද ඔය ඔයාගේ මේ පොත දෙන්නක මේකේ හදුවා නම් මම මේකේ හදුවා නම් හදන්න මේක කඩන්න එපා. terms and conditions of employment කියනකොට what do we mean by terms and conditions, right? general topic එකක් වුණ පැය 3ක්. ඊට පස්සේ 50ක් තියෙනවා ගණනාවක් මේක යටතේ කතා. මේක තමයි ලොකුම මොඩියුල්. මේකට තමයි ලොකුම කාලයක්. අනිත් ඒවට නෙමෙයි. මේකට කතා කරන්න ඕනේ පටන් ගත්තාම wages foods ordinance සාප්පු ආකාරයාල සීලක පන shop and office employees act 2000 Brava 2005 Brava 2016 right and then this one is the minimum retirement age of workers act right minimum wage of workers act මේක ඔක්කොම කතා කරා. Then අලුතින් ඉස්සරහට in the future there is no Brava Act is being amended. It has been drafted and gazetted. They know the objection portal gazetted. Now then it's a matter of maximum 1 month will be the new act will be passed. At the parliament. What is the act? Not that new act, amendment. Brava has been what? Terminated or abolished. The original is fine. Brava සියල්ලම Brava වල end දෙකේම end date එක වෙනවා 2025 මාර්තු 20 2025 අප්‍රේල් මාසයේ පළවෙනිදා සිට බලපෑමක් වෙන පරිදි බ්‍රාවා අහෝසි කොට අවම මාසික වේතනය රුපියල් 27000 ලෙස ගත කරනකොට 27000 නෑ ගැසට් කියන්නේ මෙහෙමනේ ප්‍රොසීජර් එකක් තියෙනවානේ ඉස්සෙල්ලා ඇමෙන්ඩ්මන්ට්ස් මොනවද කියලා ගැන ඩ්‍රාෆ්ට් කරා ඒක යවන්න ඕන කොහෙටද ලීගල් ඩ්‍රාෆ්ට්මන්ට් සෝරි ඉස්සෙල්ලාම කැබිනට් අප්‍රූවල් එකක් ගන්න ඕන මේක කරන්න හරිද කැබිනට් අප්‍රූවල් එක හම්බුණා කැබිනට් අප්‍රූවල් එක හම්බුණාම ඒ කැබිනට් අප්‍රූවල් එකේම කියනවා මේ අපි ඉල්ලනවා මේ නීතිපතිට සෝරි ලීගල් ඩ්‍රාෆ්ට්මන්ට් උපදෙස් දෙන්න ඒකට තමයි ලීගල් ඩ්‍රාෆ්ට්මන්ට් යනවා අපි මේක ස්කෙච් එක හදලා හරියාම ලීගල් ඩ්‍රාෆ්ට්මන්ට් එක ලීගල් කොන්ටැක්ට් එකට දානවා. දාලා ඉවර වෙලා ඒකට ඇටර්නි ජෙනරල්ගේ සර්ටිෆිකේට් එක ගන්නවා. හරිද? ඔතකොල ඇටර්නි ජෙනරල්ගේ සර්ටිෆිකේට් එක එහෙම කරලා. ඒක ආවට පස්සේ ෆයිනල් ඩ්‍රාෆ්ට් එකයි ඇටර්නි ජෙනරල් සර්ටිෆිකේට් එකයි දෙකම අරගෙන ඒ කියන්නේ කොන්ස්ටිටියුෂනල් එක බලන්න. ඊළඟට යනවා කැබිනට් එකට. මෙන්න ෆයිනල් ඩ්‍රාෆ්ට් මෙන්න ඇටර්නි ජෙනරල්ගේ කොන්සෙප්ට් එක රයිට් මේ මොනවාද කොන්කරන්ස් එක කොන්කරන්ස් ask the cabinet to approve to table it at the parliament. So the cabinet එක දැන් තියෙන ඉල්ලන්නේද මේක ගැසට් කරන්න. ගැසට් කරේ ෆයිනල් එක. හරිද? ගැසට් කරලා අපි දෙයක් බලන්න. ගැසට් කරාම කවුරු හරි ඔබ්ජෙක්ෂන් අඩු දාන්න පුළුවන් ඒවට තියෙනවා. දැන් ඔය ගැසට් කරන්න මොකේද ඉන්නේ? ඔය ගැසට් කරන්නේ මොකද්ද? ජස්පෝට් නෙමෙයි පාර්ලිමේන්තුවට යන්න දැන් ඩ්‍රාෆ්ට් කරලා ඇටර්නි ජනරල්ගේ කොන්සෙප්ට් එකත් ආවට පස්සේ තමයි මොකද කරන්නේ මේ ඊට පස්සේ කැබිනට් එකේ මේකත් ගත්තට පස්සේ තමයි ගැසට් කරන්නේ. ඒ ගැසට් කරලා හරි දෙයක් ඇතුළත මොකද කරන්න ඕනේ? ඔබ්සර්වේෂන් ඒව මුකුත් නැත්තම් මොකද කරන්නේ? කෙලින්ම මේක යනවා ටේබල් කරන්න කියලා පාර්ලිමේන්තුවට දාන්න. ඊට පස්සේ පාර්ලිමේන්තුව අප්‍රූව් කරනවා. අප්‍රූව් කරාම කතානායක අස්සම් කරපු දවස නෙමෙයි නම් මේක රෙට්‍රොස්පෙක්ටිව් නේ. මගේ මතකයේ හැටියට දාලා තියෙන්නේ පර්ස්පෙක්ටිව්. එදා ඉඳලා ඉසි දැන් ඇරියස් ගෙවන්න බලාගෙන ඉඳලා. ඒක තමයි මම උත්තර කිව්වා කාටද? මං හිටියා නම් මම විරුද්ධව. මං හිටියා නම් පාඩුවේ තමයි. මම හිටියා නම් මං විරුද්ධව කියලා. නෑ නෑ මෙහෙමනේ ඌ කවද ඉඳන්ද මේ ඔය අප්‍රේල් ඉඳලා ඉඳ රාජ්‍ය සේවකයන්ගේ පඩි වැඩි අප්‍රේල් මාසෙ ඌකට සමගාමී වෙන්නනේ මේ ඒක ආණ්ඩුවල තීරණ මොකද කරන්නේ පොඩේ ඉන්න මගේ ළඟ මේ දැන් මම කියවන්නේ දැන් වෙන මිනිස්සුෙක් ආවොත් එහෙම කියලා මං කරපු ටිකම කරලා ඉවරයි මොකද ඔව් නැත්නම්
නෑ වෙන whatever.
පැනකට ඕනේ ඒක පැනල්ටි දන්නේ නැහැ පැනල්ටි ගෙවන්න වන්නේ මේ පොඩින් මේ වැරිලා daily wage පොඩේ ඉන්න අයවැය සහන ජීවනා පනත් ඒවා අහෝසි වෙනවා පනතේ කාල 2005 අගෝස්තු යන සංශෝධනය වෙනුවට 2025 මාර්තු 31 දිනෙන් අවසන් වන කාල සීමාව සඳහා විතරයි. කියන්නේ මාර්තු 31කට පස්සේ ඒක නෑ. ලයිව් බාව නෑ. හරි. ඊට පස්සේ ජාතික අවම වේතන පනත සංශෝධනය. මෙම පනතේ විධිවිධාන 2025 අප්‍රේල් මාස 1 වෙනි දින සිට ක්‍රියාත්මක ලෙස සලකනු ලැබිය යුතුය. ඒ අනුව ආදේශ කරනවා මේ සංශෝධනය 2025 අප්‍රේල් මාස 1 වෙනි දිනෙන් ආරම්භ වී 2025 දෙසැම්බර් මාස 30 වෙනි දිනෙන් අවසන් වන කාල සීමාව සඳහා යම් කර්මාන්තයක් වූ සේවා නියුක්ත සියලුම සේවකයන් සඳහා ජාතික ඒ කියන්නේ මේකත් දීලා තියෙන්නේ දෙසැම්බර් 30 වෙනිදා විතරයි ජාතික අවම මාසික වේතනය රුපියල් 27000ක් විය යුතු අතර මේ සේවකයෙකුගේ ජාතික අවම යම් සේවකයෙකුගේ ජාතික අවම දෛනික වේතනය රුපියල් 1080ක් විය යුතුය. ඒ දෙසැම්බර් 31 වෙනිදා ඒ කියන්නේ ඊළඟ අවුරුද්දේ ආයෙ වැඩි කරනවා මිනිමම්. මේකේ කියනවනේ මේක බලපෑමක් වෙන දිනේ දැන් මේකට පුළුවන් එම්ප්ලොයර්ස් ලාට හරි කාට හරි නඩුවක් යන්න මොකක් හරි රිජෙක්ෂන් එකක් දාන්න පුළුවන් මේක නෑ ඉස්සරහට ක්‍රියාත්මක වෙන විදිය කියලා මේ ලෙෆ්ට් එම්ප්ලොයර්ස් නෑ ලෙෆ්ට් එම්ප්ලොයර්ස් ලාට අප්‍රේල් මාසේ පඩිය තිබුණොත් අප්‍රේල් මාසෙට ඒක ගෙවන්න ඕනේ හැබැයි මේ මාර්තු මාසේ ගිය කෙනෙකුට ගෙවන්න ඕනේ නෑ
නෑ දැන් ප්‍රශ්නේ ඇවිල්ලා
ඔව්
අප්‍රේල් මාසේ අයින් වුණා නම්
ඔව්
දැන් ග්‍රැටිවිටිස් ගෙවලා නම් ඒතර එයාගේ ග්‍රැටිවිටි එක බේස් වෙන්න ඕන අඩුපාඩියකනේ.
there may be because of this ඔයාලා දන්නවද අයවැය සහන දීමන 2016 එකත් repercussions කොච්චර තිබ්බද retrospective ඉඳලා අතීතයට බලපාන්නේ දන්න ඕකෙන් ගොඩක් ඇයි ඒ වගේ තමයි මේකත් වෙන්නේ අතීතයට බලපාන විදිහට ඇදුවාම මම මේ ළමයාට කියන්නද මේ නැත්නම් මේ දැන් මතක තියාගන්න මේකේ මුළු ෂෙඩියුල් එකම ඔය ඊළඟ තියෙන ඒවා මට ලැබිලා තිබ්බා නම් මම අද ඔයාලට කරන්නේ මොනවද අnder දෙනවා. හරිද? ඒ කියන්නේ මම ඔයාලට වෙන දේවල් මගේ කව ඒවා එකතු කරලා settlement කියන්නේ මොනවද? එතකොට ඉන්ඩස්ට්‍රියල් ඩිස්පියුට් නෙමෙයි settle කියන්නේ වෙන මොනවා හරි. right? දුක් ගැනලි හරි grievance handling ඒවා settle කරන ඒවා තමයි but not relevant to industrial. ඒකට මම කතා කරන්නේ ඒක. ඔයතුනේ දැන් මම මේක කලින් දැකලා තිබ්බනම් මගේ ලෙක්චර් එකට මේක මම කලින් දැකලා තිබ්බනම් ආද ඔය එකට මම එන්නේ නැහැ.
නෑ අපේ ප්‍රතිදීප් එක දැන් යූසර් පැහැදිලිව තිබ්බ වෙන වෙනම ටොපික්.
ඔව්. ඔව්.
ඒකේ තිබ්බේ අර උපමාවෙන් පස්සේ එක එක ආයෙත් කරා. ඒක
වැඩි විදිහට බලන්න. Graduity හදන්න කොහොමද මේ? Graduity හදන්න කොහොමද මේ? So those who are online, right? If you can stay, otherwise, you know, you can leave. If you want to hear, you know, we are discussing something else here. If you wish to listen, right, be with us, right? Graduity, how do we calculate graduity of a person who is working on piece rate base? Piece rate, मनुष्य graduity calculate करना होगा. Piece rate payment based on piece rate.
Past need a preceding past
6 months.
12 months.
3 months. Last 3 months වල මොනවද ගන්න? earnings average කියන්නේ කොහොමද හදන්නේ?
ඔව් ඒක වලින් සමගන්න ඒක දවස් ගන්න.
දවස් ගානේ බෙදන්න. ඒ කියන්නේ ඒ කාලය තුල වැඩ කරපු දවස් බෙදන්න. එතකොට එන්නේ මොකක්ද? daily wage. ඊට පස්සේ gratuity හදන්න. ඒක වැඩි කරනවා කියන්නේ. ඇහෙන්නේ? 30 වැඩි කරා මාසික පඩි ගන්න නැහැ මාසික භාගය පඩි ඉවරයි. 30 වැඩි කරලා දෙකම නෑ ඒක වැරදි. piece rate එකට තියෙන්නේ වැඩි. නෑ. මාස භාගය 25න් වැඩි කරන්නේ නෑ ඒක වැරදි. ක්‍රමය multiply by 14 days. 14 days. right? monthly අයට තමයි අර basic එක අරගෙන ඒකේ 0.5 වලින් වැඩි කරනවා. අපේ භාගය පඩියනේ. හරිද? එතකොට මේ monthly basic salary multiplied by 0.5. එතකොට එනවා. daily wage එකේ අදාළ මාස භාගය කියන්නේ 14 and piece rate එකේ මාස භාගය වැඩිපු කියන්නේ 14 days. not it. හරිද? දැන් මෙහෙමනේ contract employers lagi ada contract contract employment lagi ඔයා පොඩ්ඩක් explain කරන්න කොහොමද කියලා දැන් title එක දීලා තියෙනවා contract basis දැන් මාස කීයකට දෙන්නේ 6ට දීලා 6 වුණාම මොකද කරන්නේ labor department යන්න නැති එක හොඳයි title එක වැඩක් නැහැ. labor department title වැඩක් නැහැ. දවස් 7න් ගැඩුවා කියන්නේ ඔය පේනවා. right? දවස් 7න් ගැඩුවා කියන purpose එක කරේ. හරි. මේ continuity එක ගන්න කියලා පැහැදිලිද? ඔව්. වෙනවා. ඔක්කොටම අකුරු ගානටම යවන්නේ. right? contract අනිත් එක contract basis. දැන් ඔයාලා minimum retirement age of workers act එක කිව්වනේ මතකද? right? ඒකෙදි මම කිව්වා මතකද? දැන් ඉගෙන ගන්න නෑ. මම ඒකෙදි පුනා කිව්වා contract basis for fixed term contract only possible for projects. මම කිව්වා මතකද? only possible only for projects. For specific tasks within 2 years or 3 years to be paid. අනිත් කිසි තැනක fixed term අදාළ අදනවා තමයි හැමදේම එහෙම. හැබැයි හොඳ වෙලාවට ඔබට ලේබල් කිසස පැනලා. පැනනා නම් අනිවාර්යෙන් පැනලා නැතුවෙන්ද උඩ අතේ ගානක් දීලා. දෙකක් නෑ ආයි. ඔය හරි එක්චාරකින් ආපු ගම ඕවට ප්‍රොවිෂන්ස් වෙනම තියෙනවා මිනිස්සු මේ මොනවාද ආයතනවල. අපි දෙන්න මිනිස්සු තමයි මම 17 දෙනෙක් කොහොමද ඉලවලු පස්සෝන් සමහරුට හම්බෙලා සමහරුට නැහැ සමහරු බයිබල් ඉස්සරවල ඉදවලු ඉන්නවා මේමයි අවුරුද්දකට මේ හාම් පුතෙක් හැම්පල් එකක් දෙන එක වෙනම වැඩක්. වන්න ඒක පස්සේ ගවන්නේ අර බෝතලයක් එකක් ගන්නවා මොකද? මටත් එවනවා මම කොමන්තාරින් දෙන්නා ලින්දකාරී පයිලට් ගිල්ට් එකෙන් සීරියස් එකක් එවන්න. ඒක තැන්වල එක වල ලෝක තියෙන මුද්ද මේ 30ක් විතර වගේ සමානලාට ඔය මේකේ තියෙනවා. අඩු ගානේ 15ක් 20ක්. ඉතින් මේ ඒවා මිනිස්සුන්ට දෙන එක කැමැත්ත දෙන එක ඕනේ. හැබැයි ගිහිල්ලා ආම්පුදාගාවට ගිහිල්ලා ඒක කරන වැඩ. දන්නවද මට සීනියර් ඔෆිසර් කෙනෙක් කිව්වා. රිටයර් වෙලා මම එතකොට කොමසාරිස් දෙන්දාර. ඔව් මට කියනවා සර් අපි ඉස්සර මිනිස්සුන්ට සර් කිව්වා. මම ප්‍රොෆෙසර් වුණාට පස්සේ මට කියනවා සර් දන්නවද කොච්චර දුරට පිළිගා මම මේක වාර ගන්නවා. නිසා අපි ඉන්න මහරජා බුරියානි දෙන තැන්වලින් කෑම එකක් හැමදාම කෑම එක ඉතින් නැහැ. ඒ මිනිස්යාර අයිතාරයද අපි සීනෝ ඉන්න අඳුනන ඉතින්ලානේ හොඳට කතා කරනවා. ඊළඟ දිනව මන්ට කෙල ගහලා තියෙනවා. ඒ තරම් සමහර මට අහුන්නේ නැහැ අතට ඒක ගෑණි කිදියා ඉලුළු වට්ටිම සල්ලින ඉලුළු ටික නැහැ. මට අහුන්නේ නැහැ කම්ප්ලේන්ට් කරනවා. දුන්නා නම් වෙලාවක ඉඳලා නැති වෙලාම යන්න යන්නේ. ඒක උනහම උත්තර මේ. දැන් මෙහෙමයි ඔය පුංචි දේවල් වෙන්න උනා රටේ දෙවන දේවල් වලට. හැබැයි මට අනුන් කියන දේ වැඩක් නැහැ. අපිට පුළුවන් දේ අපි හරියට කරන්න. but anyway right මම කියන්නම් මේගොල්ලොන්ට මට මේක දෙන්න කිව්ව නැත්තම් ඕගොල්ලොත් කන්ෆියුස් වෙනවා. ඕගොල්ලොන්ට ආයේ ආගෙන ඉන්න දෙයක්වත් නැතු වෙනවා. දැන් බලන්නකෝ නැල්ලට ආරම් මොන හරි කියන්න පුළුවන්. ඒකම මම කියන්නම් දෙන්න කියන එක නැත්තම් ඉලක්ක. Oh yes, you can. We finished. Right. Go home now. Thank you very much.